Ready?
Ready.
Call the meeting to order for the Board of Building Regulation Examiners and Appeals for September 15th, 2016. Would you please call roll?
Okay. Mr. Steele?
Here.
Mr. Fredine?
Here.
Mr. Brady?
Here.
Mr. Cowling?
Here.
Mr. McCann? Here. Mr. Edwards?
Here.
Mr. Soboleski?
Here.
Mr. Field?
Here.
Mr. Boney?
Here. And we do have a quorum.
We have a quorum. Oh, and for staff, Mr. Colhase?
Here.
Mr. Gisler?
Here.
Mr. Knopfinger?
Here.
And Mr. Severin?
Here.
Okay.
We have before us an agenda, and I'll entertain a motion to accept.
Mr. Chairman,
Mr. Steele?
I would move to adjust the agenda and move new member welcome to item number 3 and move everything down. That is, if we have a new member to introduce.
We do?
Mm-hmm. So is that rolled in with a motion to accept?
I'll second that motion.
Thank you.
To put words in your mouth? Any opposition to the agenda as modified? Hearing none, we've got an agenda. Oops. So, we can do new board member welcome. Mr. Soboleski,
Hello.
you are new to our board. Welcome.
Thanks.
Can you tell us a little bit about yourself, and we'll go around and tell you a little bit about ourselves.
I've been in the industry for about 10 years now. I started out as a vendor, and then I decided to become a contractor about 7 years ago. I work for General Mechanical, and primarily focus on TI work. I've had a few larger projects come through past my desk as well. Any other particulars? I mean, personal life?
Nope, that's good. He's replacing whom?
Mr. Stanfield, who
Oh.
unfortunately was not able to make our meeting.
Mr. Field. Introduce yourself.
Huh?
Introduce yourself to him.
I already know him. I worked with him on the Natural Pantry.
Keith C.B. Brady, Benchmark Construction. We've worked with you guys plenty and will some more.
I'm Scott Boney, an architect with RIM Architects.
I'm Craig Fredine, mechanical engineer with PDC Engineers.
I'm John Steele, an architect with Bettisworth North.
I'm Eric Cowling. I'm an electrical engineer with EIC Engineers.
I'm John Edwards. I'm a general and mechanical contractor dealing with the city building department for the last 34 years.
Don McCann Construction, plumbing and heating. I've been dealing with the municipality for about 45 years.
Well, thanks for the welcome.
We also have before us a set of minutes from March 17 for our approval. We'll entertain a motion to approve.
I motion to approve.
Was that Mr. Field?
Yes.
A second.
Second by Mr. Steele. Any comments or discussions? Hearing none, all in favor of accepting the minutes, say aye.
Aye.
Opposed? None, abstain? One. Minutes are approved. New business is a de novo hearing, BCA 2016, regarding refund of permit fees for finished and unfinished basements, I believe. There's a, let me first go with Mr. Severinson in the municipality. You've got an objection or the building board jurisdiction to
That's
hear, well, to even hear it, I guess, is you've got a recommendation not to hear. Oh, so it's just the methodology and not refund? I stand corrected on that. Thank you.
And I guess I didn't quite.
Three-member panel, so that's why you got it. So you're just seeing if you were going to hear.
Well, yeah, apparently there's as I understand it, there's a recommendation from the municipality to not even hear this case. Is that correct, Mr. Severin?
There is, and I can address that, although I understood it all along as a request for a refund. If it's not, as Mr. Thompson just clarified, then I think that my objection, the objection is that I just don't believe the board has the authority to issue an order that says municipality write a check for $5,000 for things that happened historically to make them right. I don't think that's something the board has the authority to do. But if the request is not to, in fact, do that, then, which is what I just understood from Mr. Thompson, then maybe it's not necessary to debate that or really discuss that. Maybe my motion is essentially moot if I misinterpreted the request all along and it's not an actual request for a refund.
Alrighty. So we can proceed then with a consideration to hear this, which is our first step. Does the board wish to review this de novo hearing?
Mr. Chairman, I don't know if one less person would be a quorum or not, but I may have a conflict of interest. I hire Scope and will continue to hire Scope. I want to make that known to everybody on the board.
I was going to get to disclosures as we got into election to hear, so let me put that aside for just a moment. That to entertain, first of all, does the board has the option to hear the case or not, or accept the findings of the three-member panel at face value and not hear this?
It's my understanding that the three-member panels can't vote on this, but once it is voted, then we are able to hear it and provide our opinions.
That is correct. So the three-member panel was
Mr. Steele, Mr. Cowling, and Mr. Field.
so those three members are not voting members in to hear.
And Mr. Boney, if I may, I don't want to interrupt you, but I don't know if you're looking at 2310 103.4.4E. I don't know if you have it in front of you, but it explains the voting process for the discretionary de novo. It's just
Right.
and there was a slight change in the 2000.
My only question is what's the number that we have to have here?
This came out as part of the
Yeah.
the packet, but the question, I guess, is it 50% of the appointment or 50% of the
Of
attendance?
everybody who's present,
And-
as the board member.
Mr. Steele, it did change. It was appointed members, and now it is members present.
That won't go. Yeah.
And
50% plus one of the members not disqualified from voting under this subsection.
I think we've got a new code versus old code
Because I think we
issue.
clarified that as to members that are present.
You're right. That's what the new code says, and I think depending on when people's books were issued or
Book is updated, yes.
right. So
Print them out and get them prepared.
the new code, and maybe I could just read it. Would that be helpful?
That would be very helpful.
Okay. It's subsection E, again, under 2310-103.4.4, discretionary de novo review hearing. In its sole discretion, as determined by majority vote of the members in attendance, not disqualified from voting by conflict of interest or under this subsection as provided below, the building board may accept an appeal decided by a three-member panel in whole or in part for de novo rehearing by the full building board.
Oh, so we do have to do disclosures first then.
And the other thing, that when it says not disqualified from voting for conflicts of interest or under this subsection, the under this subsection is the people who were members of the three-member panel. So,
Right.
yeah.
We do have to do disclosures first. And CB, you mentioned that you do work with Scope.
Yeah, and I plan on continuing with Scope.
And let me see, would the decisions made by this in any way financially alter or provide you any gain in your work?
Might slow down my permitting review.
You know,
There's no financial gain.
I don't know if I can say anything, but I guess I'm still, at this point, not clear if this is reheard, what we're hearing, and if we're to come to a conclusion and make a decision, what is that? What is it for? What are we deciding on? I have no idea. I don't have a clue.
As I understand it, and correct me if I'm wrong, the whole hearing is about the value to be charged for finished and unfinished basements. No?
It's about whether or not policy is in effect. If it's in effect when somebody applies or does anything with regard to municipal budget and statement on taxation. You know, policy articles is in place and adopted as per 23.1 based upon many individuals to get valuation in mind. Building officials, they execute so he went ahead that the policy doesn't apply, but it does, and that's what I'm feeling. I think he has to go back to the building official and administer a policy that's been in place for time. Three-member panel got caught up in a whole different aspect of what I asked. The policy is in place. Whether it's whether it was in place or not, and the building official has to administer that policy or not. That was the whole question from day one of the second start. Policy was in place, they chose not to meet that policy and revise that policy. And therefore, that's why I have confidence in our policy. Everyone was to do that. What policy said, what value, all these other things. That's why I think I'm happy with it. And why I realize the building board, because I thought then maybe we could get to the bottom of the exact question I asked on my application, which was policy in effect? And if so, don't That's the whole deal. That's all. Not asking you to
Without getting into the the hearing of this and the testimony, Mr. Kulas, is that what you understand?
Well, I had trouble hearing some of what Ron was saying. I'm not sure that I didn't hear him.
I'm not sure the PA system is working as well as it should. So having heard this just for the first time now, what I wrote the denial on was a request for refunds of the fees in question. So my interpretation, I think our interpretation, that was that we were deciding on a refund request.
Right. So, Mr. Thompson, if you'd take a glance at your appeal form, basically the very last sentence on that form, all permits should be refunded to everyone that has been billed incorrectly.
That's the result. It could be the result. The policy's in effect. That's what I want. If you guys say,
Is your mic on, and can you turn that toward yourself a little bit, because it's real hard to hear? That helps.
if a policy is in effect, you administer the policy. They did not do what the policy said. Therefore, I'm appealing that he decided to go other than what the policy said. Yes, the result might be a refund, but that's the building official's decision to meet the policy or not. I appealed because he is not administering my request as per a policy that was in place when I submitted it. And so I think the building board should review the fact, just like I said on here, that policy R01 was in effect at the time that I applied for the refund. Therefore, the building official should have to administer that policy as written, whether it was determined legal, not legal, whatever. It was in place for 20 years. It was in place. It's in place then. It was not a life safety issue. Therefore, it should have been the decision of the board to go back to the building official, let them administer the policy as written, as it had been enforced and interpreted for 20 years. Then the result might be the refund, but I'm not asking the board to talk about the refund. I'm asking the board to review whether that policy was in effect, as legal, by code, and it was changed in contrary to what the code is. That's what I tried to argue at the hearing. It was argued into the point with regard to what was in the policy and whether the policy was legal or not. That's not my point. The policy was in place for 20 years. I applied for something that was as per policy. They chose to change the policy overnight and make retroactive back changes, and that's not right, because there's 100 policies that you guys use every day, and if they start doing that because they don't like a submittal, that's a problem, and I'm very adamant that that's the issue here. The policy should just be reprimanded back to them, that it was legal at the time that it was applied for, administer it correctly, and move on.
Mr. Ferdine.
So since we are at the point of identifying conflicts of interest in this process, it looks to be if we even have the authority to even state the revised or clarified request, if we were to go in favor of stating what the appellant has requested, that could be the basis of a financial gain for somebody for a refund. So I guess the question of what our result of this, could that financially benefit any of the members of this panel? That is kind of the question. Would what this panel decides even be admissible in a court case for the basis for a future referral or for a future refund request through the courts or whatever other process? Or is it just this group over here agreed or disagreed with us? Because if what we say does have an impact on whether those refunds are done because of a policy, basically, do you have to live with the policies you have in place? If that has an impact, then we would potentially have a financial gain conflict.
They've revised the policy, and they legally revised it now. I asked for 2 different companies, that's it. So if anybody here is on Northern Home Builders, or if anybody's here in Spinell Homes, that's the only 2 companies that are affected by the requests that I made at the time when the policy was in effect.
Mr. Edwards?
Are we going to vote on hearing this, or are we just going to hear this without a vote?
I think we're trying to get down to what it is, and I think we're getting pretty close here, that we can get down into the weeds on this thing a little bit more as to where it's going to go, but I think we are getting a little bit close to a hearing here myself. And with the disclosure, too, our company has worked with Scope before and will probably work with them again. I have no financial interest in this particular claim, would not benefit financially for it, and it's up to the board to decide if I should or should not participate.
I'd like to see a vote.
So, in my case, if there was ever, I'm a commercial contractor that does some residential construction, and during this time frame, I have done a basement project that was unfinished. And so if this led to any sort of further refund, I think there is conflict of interest because I'd get potentially money back. So I think it's, however this is decided, if it's only down to Spinell and the other outfit, there's no issue on my end. But if it were to go the next level into other claims, I think there would be financial gain if the house was done at that time, which I believe it was.
So the first thing we got to deal with is, well, let me take the easier one first. Does anybody have a problem with me participating?
I don't think hiring Scope without a personal gain is a conflict, now that you bring it up that way.
So, not a question there. I can participate in hearing, no objection. And Mr. Brady, does anybody see a conflict of interest if Mr. Brady participates? Hearing none, he can participate.
Good.
Okay, now that leaves 1, 2, 3, 4, 5, 6, 7, 8, 9 of us left. And we have 3 present that cannot. So 6, we need. Is the number going to work? Yeah. We'll need 4 positive votes to hear. Now, Mr. Field cannot vote. Mr. Field, excuse me. Mr. Cowling and Mr. Steele cannot vote on this. It is simply to hear the request. I don't think we got to do this by an oral vote, or anything more than an oral vote. All in favor of hearing this request, say aye.
Aye.
Aye. Opposed? Abstain? Hearing none, we've got enough votes to hear that we will hear this. I believe decorums puts the municipality at first presentation.
So I want to make sure, Mr. Chair, my understanding is that it's not the full presentation. I outline the case, and then Mr. Thompson would present first, and we present after. I want to make sure I understand.
Yes.
Okay. So just a simple outline of the case is we've touched on some of it already. In, I believe, November of 2015, Mr. Thompson filed a refund request for 2 clients for
That's true.
this discrepancy.
Excuse me, we've just been reminded we skipped a step here. For all those who would be testifying, please raise your right hand. Do you affirm under penalty of perjury that the testimony you're about to give in the matter before us is the truth? If so, say yes.
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 Thank you. Thank you for the reminder. Okay, excuse me, Mr. Kulas.
Okay. Excuse me. Mr. Thompson filed a refund request for 2 residential home construction companies. That was in November. If I give you too much detail, stop me. In January, I was not the acting building official at the time. The municipality began looking at it. I don't know what happened in the intervening time. As we looked into it, in consultation with the acting building official at the time and Mr. Knopfsinger, we became aware of the fact that the policy that established valuation for finished basements appeared to have been the policy appeared to have had the effect of setting fees without the action of the assembly. We took that question to the Department of Law. They confirmed our interpretation, and sometime in that time frame, I became the acting building official. I wrote the letter on May 25th denying the refund. Mr. Thompson appealed that to the 3-member panel in July. The panel heard and found at that time in favor of the municipality. Mr. Thompson has appealed that, and now we're here to respond to that. I'm not sure what else goes into basic introduction of the case, but those are the basic calendar for what happened.
I'll turn it over to Mr. Thompson. If you may make your presentation, please.
Okay, those of you that don't know me, my name's Ron Thompson. I was a building official for, 15, 18 years for the municipality of Anchorage. I administered these codes. I wrote these codes. I wrote the policies. If you look online, probably 90% of the policies still online have my name on the bottom. That means I wrote them. I know what they say. I know what they do. I know why they were created. They wouldn't be created if I didn't need them, if they weren't important, and they weren't directed by the community. Those of you that know me when I was in that position, absolutely, I work for the community. I work for what's going on here, making it fair for everyone. The reason why you write policies is to make it fair, so one person doesn't get it, and the other person that everybody gets the same treatment. That's why policies are written. The code allows for policies to be written by the building official. This policy in particular, R01, was written and started by Jerry Waite, building official prior to me. It was subsequently re-edited 3 or 4 times by Ron Watts, and then by me. I was participating from day one on those meetings, and the whole reason for them was to do with AHBA and the cost and value that the assessor's office was using while doing building permits, and then all of a sudden at the assessor's value they were valuing the unfinished or finished basements at a higher value. That's why it was done. We came up, we discussed, and then it was like, okay, all these things in this policy were there. It was created, and the big issue with regard to the policy is it's a policy, just like the other 100. If you walk in daily, and I walk in there daily, I have to understand the code. I have to understand every policy that's in place, and I administer my permits for everybody that I work for, and I work for a lot of different entities in Anchorage. They pay me to be accurate with regard to code, policy, and look out for their better interest. Last fall, I came into the municipality with a residential permit with a basement. When that basement was calculated, I wrote the fees. I know how they're created. I wrote them. I calculated the fee in my spreadsheet that I have. I went in with a check, and when I got to the counter, they calculated the fee much higher than what I had. And I was like, wow, that's kind of weird. I mean, I have the formulas that I created. So anyway, Gretchen came out. That's the head of the permit clerks. She came out, saw me. She says, oh my God. we've been administering that incorrectly since Hanson started. That's what she said. She reduced my fees, which show that the interpretation in my background and her background was that that was not the correct way to calculate fee. The way that the computer program is was not correct. So therefore, it infers that the interpretation of the policy was that basements were at the rate in the policy. So at that time, policy was in place, policy was enforced, policy showed an interpretation that matched. She decreased my permit to that exact amount. And I said, okay, well, I'm working for 2 other builders at the time that significantly build in Anchorage and do different permits. I asked both of them, do you build with basements in Anchorage? There are 2 clients of mine. I'm always going to look out for the clients that I work for. They said, you know, we have. Spinell, I think, said probably 10% a year have a finished or unfinished basement in it. Northern didn't have nearly as many, maybe 1 or 2 in that whole time frame, maybe, he said. But anyway, my view was I'm looking out for the better interest. I had a policy. I had an interpretation of a policy, and so I asked for the refund. At that point in time, I was told that they've changed the interpretation. They took all the documents, the policy, all the things in my folder, the how to calculate fee form, all of that, pulled off outline immediately, just like that. Said it was changed. This took place after 6 months time frame, obviously, because I submitted in November and got the letter in May. So sometime in that 6 months, they went through this organizational thing and changed the policy overnight. Everything went offline, and then I get a letter that says we're revising, and therefore we found that it's legally not correct. Well, I don't know, I probably worked for 6 or 8 municipal attorneys, all of which had said it was legal. So, I mean, legal determinations come and go, and they change all the time. It is what it is. That's part of the game. Some policies come, some policies go. In this case, then I pointed that out to Kent. He goes, oh, I understand there's a mayoral policy, and I'm going to read the mayoral policy because that's the big key here with regard to, you heard that the policy was in effect. The interpretation was they gave me the refund, so at the first one that I applied for, therefore the interpretation was the same as when I wrote the policy. And the policy for the municipal mayor's office says, it is the policy of the municipality that any changes in past policies or interpretation of regulations and or provisions of the building codes shall not be enforced until a 30-day advance notice has been provided. This 30-day notice period is to offer time for comment from the community. In the event the building official determines that an imminent life safety condition exists, which can be lessened by the changed policy, regulation, interpretation, or provision of the building code, no advance notice is required. So that's all standard. That's in there. It makes sense to me. Here's a policy that was in place.
Is that in our packet? That what you
Yes.
read?
Yeah, it was submitted.
What page are you looking at?
It was in my...
Page 5.
Page 5 of 9 in my application package. So that's the mayoral policy that's dated and in place today that the mayor has in place for one reason, for exactly this reason. Do not change enforcement without giving proper due notice to the public and to the industry. So then if they do have issues with it, they will go and have the ability to make comments, and then they can either revise it or change it or not. That's the issue. That's how it goes. That's bottom line. The issue that I have here is that the policy was in place. Whether it was determined to be now illegal when a year ago it was legal, I don't know. I don't get into that. My view is the policy was in place. I wrote it. It was also written by 2 building officials prior to me, so it wasn't just me creating this thing and me trying to say this is what it interpreted now. That's what it was, and it's been for 20 years it was that way. And this is what's frustrating about this scenario. a municipality, and that's why this mayoral policy was written, because of situations that builders, developers, architects, engineers, all of folks that you guys work with and are each and every day. So they have a consistent process and submittal process and information provided to the public so you can submit drawings and not have this, wow, something's going to change today, and all of a sudden I have to do things different. That's what these are for. That's what happened here. Overnight, it was changed. Everything was stripped off the line. Then when I let the building official know, and granted, Kent was brand new at the time. He didn't know about this the mayoral policy. I did. I helped write it for the mayor years ago, and at this time, I mean, it's really frustrating to see. But the great thing, Kent goes, oh, gotcha. Immediately, he put it out for 30-day notice, and that's why I said just a minute ago, policy has now been revised correctly through 30-day notice. The community commented on it, and the other nice thing is not only are they changing the policy, they took the numbers out of it, the values that they were saying were in discrepancy, and they just put in place a change to those fees so they will be lowered through the correct processes based upon this administration's ideas. That's fine. That's the process that I look for. The problem I have is changing a policy R01, without notice, after I applied and caught them charging too much for many permits over the course of the last 5 years that Hanson has been in place. And their reasoning behind it was, oh, it was programmed in Hanson, therefore that should be how it is. I don't really want to go into the body of the code. I just want to say, policy is here. It was in effect. The mayoral policy says that policy will be in effect, and you can't change the interpretation of that without a 30-day notice. They gave me a discounted permit on the basement prior to, because that was exactly what the interpretation was. And in this case, I just want this to go back to the building official, administer this request as per this policy that was in place at the time, and whatever comes out of that is what comes out of the written policy at the time. And that's why I'm adamant. That's why I spent the money to come back. That's why I felt we got off track at the third party. We got too much into the body of whether this policy is good, bad, or written right, or correct or not. It worked for 20 years, but at the end of the day, that's what got wrapped around. Also, the municipal attorney kept saying, you guys can't hear this. You guys can't hear this. And I'm like, I'm not asking you guys to determine a check to write to my clients. I'm asking you to give an interpretation that says policy R01 was in place, and as per the municipal policy and that policy, the building official needs to adhere to that policy that was in effect at that time, and they always can change. And that's another, after that meeting, I also requested the mayor's office to take my name off policies and put other people's names on it, because if I wrote them and my name's on them, and I interpret them, and I made the policy, I think if they're going to change that interpretation, they should put their own name on the policies. And that's kind of what this comes down to. You can see that you should not change policy, and this is just one of the policies of the 100. If I go in every day dealing with issues, and if I go in and I have to risk the code just automatically being able to be changed that day, a policy being able to be taken away once I apply for, I mean, I can't go to you guys, and if I do work for any of you, and really truly say, this is how we're going to do it, this is a policy in a place, not thinking that it might change. That's not how this should be done. It's not how code should be administered. These should be administered as per these written documents, as per the policy, and if you don't like it, you're going to have to suck it up and do it that way until you change that policy. And that's what they've done. They've changed it, and that's more power to them. That's fine. That's clear. And at the end of the day, then we have a policy that we can follow. But until such time, you can't be taking policies away only to just at the whim because you don't like them. Or all of a sudden somebody says it's illegal when, I mean, like I said, I dealt with many municipal attorneys, and every one of them had different interpretations, and many issues that I dealt with, 1 year would be fine, 3 years later it would be completely different interpretation. It's the nature of law, and I would think that anybody would want, if a law is in place, you don't want that law changed after you get, if you have something in regards to that. That's all I'm asking. I think it should go back. I think the policy was in place at the time. I know it was. I know the interpretation was because they refunded on another permit. And so in this case, I just think they didn't like it. I found a loophole that they didn't like. But you know what? It's not a loophole. It was in place for 20 years. And all of a sudden it just was determined that it's not. And I don't know why that determination was made. The policy worked great for 20 plus years. And I think that it's like I said in any policy or any code. You may not like it, but you enforce it as written until such time you either go and change it or you legally change it or you revise it as per the policy and things in place. These things are in place, and that's why I think it's so important to keep those things in place. And and as my application said in the beginning, it just talked about MOA policy R01 was in place, and that's what I'm asking to get put back in place and let the building official adhere to the requirements of that policy as they were in place at the time, and not be able to just change it like that and change it overnight. And that's where I stand, and I'm pretty strong about that piece because, it's important to keep that in place. And those of you that deal with the building department, you guys all know it's important for consistency, and it's important to be able to know what you're going to get into when you're working with clients and you're spending the money that you are to create plans, to create buildings, to buy buildings, all that. It's very, very important to keep that integrity in place. And that's all I ask in this case. It's not really going back and trying to create some big crazy thing. I am very worried about the fact that if there's 100 policies and they don't like a policy that you come in on, that they can change it like that, and that's not good practice. And I think the mayor policy that is in place and legal and signed by the mayor is important to have in this place. That's what you do. That's what we follow, and that's what I had to follow, and that's what I respect, and that's what I hope everybody else follows, and hope you guys all understand where I'm coming from on this.
I've got a couple questions for you here. On your package, page 7 of 9, you've got a copy of the back page of the building permit application. Is that?
That's the old form that they took offline. It didn't have a number 1.3 or 1.3 next to finished or unfinished basements. So the interpretation of this exact policy is exactly like the interpretation that was done on that permit that they gave me a refund on.
Okay, and
now this is revised.
Yeah, was the permit as of November 2000?
Yeah, somewhere in there. Right before the time that I filed for this other refund was when I filed for this other permit and found the error.
Now, as I understand from what you said, they have since altered the policy,
correct,
put it out for public comment, and done it through procedure.
Correct.
So, do you have any qualms with that new policy that's in place?
I don't have any. Well, I thought they should decrease but they did that through assembly ordinance now, so it just went into PACE, I believe. Is that not right? You submitted, Ross, I think?
Yeah, through the chair, the draft ordinance went into PACE today and should be heard by the Assembly for introduction on September 27th.
Okay.
And so the process, they took a 30-day notice, they took everybody's input, and they created a policy. That's what you do. You don't change it overnight. You don't change it without notice unless it's a fire life safety issue, and that's what it clearly says.
So I guess I'm a little confused as to what you're asking for, because what you're asking for is a modification to an old code that has been since modified.
This is all came into place before that code was modified. That's the whole question. They made the change after I applied for the request. They changed it. They changed it 6 months after I applied. It took them 6 months to decide what they were going to do.
Well, I guess what I'm asking is, what do you want us to do now?
I want them to adhere to the old R01 policy, my request that I submitted in November, as per the old policy that was in place, dated and signed by me, that was dated April or August 7th, 2006. That was the policy in place at the day that I applied last November.
For those older permits?
For the permits that I requested in my request.
Okay, so you're not challenging anything with this new policy I guess goes into
it's done now that Kent knows, They did another one like that too. Now the process is being followed, but in this case, it was not.
Okay, I think I know where it's going. Other questions, Mr. Steele?
Mr. Chairman,
Get your mic, please. Thank you.
Mr. Chairman, Mr. Thompson, I'm hearing that you're very explicit that monetary is not part of this deliberation.
Not part of your deliberation, but
yet your packet, your appeal, contains many references to refunding being part of that. And my question of you, relative to our action, which is to support your viewpoint of policy and it being enforced, are you willing to extract any language from your application relating to monetary reimbursement? And the reason I ask the question is, if I'm correct, you're wanting us to just support that the policy is in place, and based on what we're hearing from the Muni side and your perspective, the money issue is a separate issue.
the money issue is between me, my clients, and the building official.
Right. So are you willing to extract all your references in your appeal to monetary reimbursement?
Absolutely. Yes, because the decision of if R01 is in place and in force and the building official has to adhere to it, then it's between me, the building official, and the numbers that are in that table.
Okay, the question is a subtle one, is if, for example, we approve this and we don't make modifications to your appeal, I think it goes back to then we have acted on a document that has references, and is there inference that we are supporting that? So my question is, again, are you willing to take a moment, go through, and we can take care of line by line and strike these out and then rehear this, or hear it with that modification?
Yeah, those are all the issues that I would argue with the building official. Yeah, obviously, if the policy's in place, then he needs to adhere to those. But I can see in the appeal what you're saying. Yes, take the numbers out of yours and just refer back to, is R01 in place or not?
Yeah.
Right? That's what you're saying?
Example, on page 2 of your appeal at the bottom, the last sentence, and this was brought up by the chair earlier, saying that Hanson incorrectly calculated them, all permits should be refunded. Now, one could argue the word should, it's not saying shall, but that's a reference. Then I go to the next reference that I've found, which is on page 9, and it's titled APP 11. Your fact number 7 says the building official shall refund a fee that is paid and collected in error. And then in your conclusion, you have a line in there that says, I believe the MOA should review all permit fees paid for unfinished and unfinished basements be refunded to all permittees who were charged in error. Now, there may be others in your application, but those are 3.
I don't have a problem taking those out. The effect is the building official will have to do that based upon the policy. But I don't have a problem taking it out of the appeal, because the appeal, I see what you're saying, and yeah, I don't have a problem. Those are, I mean, they mention them all there throughout all their documents too, all those same type of things, so. I mean, I don't have a problem if we do that, but you could do the findings of facts and the conclusion of law that strike all those things too.
Well, and again, I'm kind of in a territory here. We've got legal opinions for the city. You obviously have your advice. We're basically floating with no input about what our action with those sentences in there are construed if this goes further, and that would be to a district court. And I'm just wanting to find out if you are in fact asking us to just deal with the policy being in place, then I'm suggesting that maybe we should take a moment and modify the appeal to speak directly to that, but I could be off base.
I mean, I guess they would have to do the same and throughout all their documents. And if that's the case, then I don't have a problem with that. I mean, bottom line is the policy was in place and it needs to be adhered to. So if you want to drop everything else but that, that's bottom line, and I think it's pretty obvious by the policies in place that it is. And so then they would need to strike their entire submittal too,
Well,
or most of it, all those same type references.
I guess all of their positions on it is we have no position dealing with refunds. So I think they've stated it fairly clearly in all of their documents, and I just want to have a balanced field. And again, maybe other members of the board can speak to this if I'm way off base. I'd like to hear that, but I just, the easiest thing for me to resolve this is to you to say I'd like to strike these following lines, and everyone accept that as what we're dealing with, but that would be your choice, I guess.
I mean, I don't have a problem striking or putting language in there that allows it to go back to the standard normal procedure that Sam has done in other cases, which is 2 years limited. I mean, I don't know what exactly that you want to, I mean, I don't need a determination by you about refunds. I need a determination to you that here's a policy. The building official didn't follow the process to create policy or administer policy. That's what I need you guys to say. Then it goes back to them, and they can do whatever part that they want. But I mean, at the end of the day, the policy was in effect, and that forces them to sit at the table with me and discuss exactly what I have always said. The policy was in a place, whether you like it, whether you don't, whether it's legal or not. We thought it was legal at the time, or we wouldn't have signed it. So, I mean, however you want that worded, I can word anything to that effect and take all those references out to refund. I have no problem with that. But you see how their response, I had to kind of tailor my appeal toward everything that they told me was the issue. So all those things that I put in there are for one reason, which were to combat everything that they put in their letter in my denial. So that's why it's in there. So if they were to change their denial report, then, I mean, there's probably no reason to change their denial report because they're using things that are outside of that policy. And same thing with me. I just combated their denial when they have no basis to deny it when the policy was in place. So whatever you want to do, I think I hear and understand what you're saying, and I don't have a problem doing that if I take all, I mean, I would hope that they would see the same thing and do the same thing. It's not fair for me, because if I go strike it out and they don't, then all of a sudden there's a different dynamic to that whole thing.
So I want to step in, John, because, I mean, you're totally right. I mean, we're supposed to hear this based on what's written in your appeal. And if your appeal says that you want refund, then that's what we have to base what we're hearing on. So what John is saying is I'm sensing he has some support for you about what you're saying you're wanting. And that's just to support you and say that that policy was in effect. But if you leave the dollar value in there, then that may lose a lot of support. So I totally understand.
I don't need it to be in there because...
Well, but that's what it says. And that's where we started. That's what's on this and throughout all your documents. And that's what John's pointing out. If you want us to vote on this, then if you want to remove all references to dollar value, anything that has to do with refunds,
it's done.
Then
I mean, but I don't even, to tell you the truth, I don't even know if these clients have any permits that are involved with these numbers. My issue is the policy is in a place, and maybe they do, maybe they don't. And I can take that out, no problem. And if that's what you're saying, no problem. I mean, I can take those references out completely. Just remember, why they're in there is because of their denial of my request. So an appeal is supposed to go hit every one of their topics so you kind of combat theirs. So if they used all those topics, I mean, I don't have a problem removing those. I don't know whether that hurts me in the long run or not, but I will remove those for you as that, because it's about the policy not being administered correctly. And if that helps make the point that you're making, no problem. I can take 5 minutes and I'll delete those lines out exactly that you want.
Mr. Steele, you started a sentence and
Yeah, I was just going to say, Mr. Chairman, it might be appropriate, I appreciate your responses, Mr. Thompson, to hear the other side, but a bit kind of the dog nipping at the heels. Maybe we should call a break for 5 minutes, and if Mr. Thompson would like to make those changes, then have it entered in the record where those changes are made, if that's what we're going to be hearing, would be my suggestion. I know it may sound out of order, but I'm hearing there's an agreement to do that, and
I second.
Mr.
Thompson, would you still say that they have to do the same? Because the May 25th letter subject line is refund request, so it seems to me that whole letter would then have to be...
That's what I think should happen, but at the end of the day, I still stand to my point that the building board can make findings of facts and conclusion of law and meet any one of those and say what's correct and what's not correct. So, I mean, whether we do that or not, you still can tailor your response and your appeal, approval or denial based upon exactly what you want it to say. So, I mean, I would hope they would do the same, but if I take it out, then that's my job to negotiate with them once it goes back to them and they know that this policy was in effect and they're supposed to adhere to this effect, then they should be meeting with me and discussing to that effect. So at the end of the day, I think they're all good people. I have no problem doing that to make it easier on your decision because that's bottom line what the decision is about. So at the end of the day, I have no problem doing it. I'd like to see them do the same, but if they don't want to, that's fine with me as well, because I think I think you're understanding the point and the condition and the reason why I'm here.
Mr. Edwards.
I think we can vote on parts of this appeal that we have authority to vote on and recommend to the building department. We don't have to recommend a refund. We don't have to deal with that monetary portion of this. We can just deal with the things that we know we have authority to deal with.
Mr. Fields.
Oh, I was going to say that should we hear the rebuttal? And
that's about where I was ready to go, too.
And then make the move to do whatever we're going to do after we hear the rebuttal?
I would like to do that because I think some of the things that the municipality may present may fall into this, and if there's got to be alterations, then we can do it all at once, if that's acceptable to you, Mr. Steele.
It is.
Anything else for Mr. Thompson at this particular time? There is going to be an opportunity for him for a rebuttal afterwards, so hearing none, I can turn it over to the municipality.
So we'll confess we're a little confused as to what our response is right now. Not what we want to say, but where we are in the agenda. Are we presenting our case now?
This is your response to his appeal, yes.
Okay, thank you. So I would start by saying we don't dispute much of what Mr. Thompson says, what Ron says. The Hansen program had a mistake in it. We don't dispute that. The policy, I would say, was in effect on the date that Ron applied for the refunds. We don't dispute that. Our position and what is laid out in the July 7th letter, and I think pretty clearly, is that that policy was not only an error, it was illegal. And that, excuse me, that's the basis of our decision. And I would also
Can you repeat that, please? It was not only, what?
The policy was illegal. The portion of the policy that set a fee was illegal. And the reasoning for that is laid out in my July 7th letter, and I'll go through that. I'm touching on a couple things. I'm jumping around a little bit. Ron, Mr. Thompson mentioned that we didn't follow the 30-day notice process for removing that policy. He's correct. We removed that policy as soon as we determined it was illegal. And we did so because it was an illegal policy. Ron pointed out that there are provisions for life safety. Our position, our thinking after consulting with the Department of Law was that if a policy is illegal, it should be removed immediately. So that's what we did. We agree that developers and contractors and designers and engineers and architects deserve consistency. I know that Ron strove for that as building official. I know that his predecessors did. I know that I do. Policies generally, as they're written, do not go to the Department of Law for review. So Ron mentioned that in his opinion that because that policy had stood since it was first enacted in 1996 by one of the previous building officials, that because it had stood the test of time, that it was presumed to be legal because no municipal attorney had stated otherwise. I believe that's essentially what Ron said. Those policies don't generally go to the Department of Law for review. So again, our position is that it was an illegal policy. I would also say, I said this at the three-member panel, I would say that when my immediate predecessor as acting building official received Ron's refund request in November, she came to Ross and I, and we talked it over. And the initial impression, before diving into the legal side of the initial impression, was that Ron was exactly right, that because the computer program had been incorrectly calculating fees, that we very likely owed a refund. As we looked into it more and into the code side of it, that's when it became apparent that there was more to it. Ron mentioned several times that because the policy was in effect at the time, whether it was legal or not, that it should stand. I would submit, and I would defer to my esteemed legal counsel for examples, but that there are numerous examples, untold examples of situations where laws have been determined to be illegal. Sounds like a redundant statement, but laws have been determined to be illegal, and they're overturned by bodies with jurisdiction, state Supreme Courts, the U.S. Supreme Court, other courts. So that's kind of my preface. The specific argument we present, upholding that the policy is illegal, is found in my July 7th letter. There I cited several Anchorage Municipal Code chapters and sections. The first one on page 2 of my letter is chapter 3.99, fees, fines, and penalties. And subsection A, paragraph A states, fees means the amount established by code. Those are my highlights in the letter. In the next highlighted section there, chapter 1.05.060, it's unlawful for any person to alter the code except the assembly. And then the third one I highlighted there is that the building official can clarify and interpret code, cannot waive requirements of the code. When you take all of those together, I guess I should back up for a moment. This policy that established valuation had the effect of setting a fee, because fees per code are based on the valuation of a structure. All the other structural types in code are referred to, they're addressed in code, and they're referred to the International Code Council and the Building Valuation Data Chart. This was the one sole example where a valuation was set specifically in policy, and that valuation of $50 is multiplied by the factors established in code and had the effect of setting a fee, because the fees are based on the valuation and the factors. So took me a while to get my mind around it. It's convoluted, but when you follow the code path, the policy set a valuation. The valuation is used to establish a permit fee. So that valuation had the unintended effect of setting a fee in contravention of code. That is the basis for the denial of the refund request. That's the basis for our argument at the three-member panel. It's the basis for our argument and presentation here. Again, I don't dispute much of what Ron says. I think we all wish that it was a different situation, but I believe that we, the municipality, and any body having authority, can't pick and choose when something is convenient to follow and adopt and when something isn't. This is inconvenient for us. We don't like to be in the situation of having to withdraw a policy on short notice because it was illegal, but we strongly believe this is the right decision. I think that's all I have. I'd be glad to answer any questions unless other members of the panel have anything to add.
I have a few questions. So if you look at the building valuation data chart, is there a line item in there for finished or unfinished basements?
There is, I'm sorting here, there is no valuation in that chart for a finished basement. And correct me if I'm wrong, Ross, there is a valuation established for unfinished basements. So I think I discussed this at the three-member panel. When you read that body of guidance in total, it's clear that that chart addresses all different manner of construction types, groups, occupancies, even goes so far as to address unfinished basements. But it's silent on finished basements. So the reasonable inference one draws from that is that the valuation for a finished basement was intended to be the valuation of full residential construction. And as an aside, as Ron mentioned, we are moving right now, working with the Assembly, to reduce that, because as we discussed at the three-member panel, a full valuation assigned to a finished basement is too high. Everybody recognizes that, I think. So we're moving to have code introduced and hopefully adopted that will reduce that valuation. But a long-winded answer to your question, Mr. Chair, there is no valuation for finished basements in the building valuation data chart.
And we don't have that document at all. Do you happen to know what the valuation for unfinished basement is published in that chart?
Excuse me, $15.
15?
Yes, and it's a footnote at the bottom of the chart, and if you don't have that chart, I believe I have a copy I can provide to you.
MOA 12.
It's on 11, 12, and 13 for the different years.
Gotcha, okay. I didn't get into that to understand what I had.
It's actually footnote B in the chart.
So, how would you how would the publication deal with a finished basement? Would it be at the value of the primary value above?
Correct, it's just finished construction.
So you'd go to R3 residential, 1 and 2 family, to more than likely a 5B, and it would be $112.65.
Correct, multiplied by the local multiplier of 1.3.
Okay. Now, is there any precedence set? This is probably more for legal, that having this policy in place for a number of years that had been enforced in such and such way that we kind of, yes, it does it have some rights to it at that point because it's been enforced in such a fashion until it gets changed?
I think that would be the argument that people would certainly make. It's really difficult, generally speaking, to make that kind of argument against a municipal or other government body. It's a very uphill battle because the courts and stuff, if it were brought in court, want to, they recognize that sometimes municipalities get stuff wrong and want to be able to turn around and make it right. So, we have the ability to change it. I guess if people, it'd be harder if people truly relied on it, then it might relied on it to their detriment or something, but it's a hard argument to make specifically against municipalities, that something like that's grandfather. If somebody said I set up an entire business plan solely based on the fact that I could do basements at this rate, and I don't know, there might be something there, but
where I'm coming from is, for a number of years, it was $50 for finished basements, $15 for unfinished basements, with no multiplier on it, and that was on a municipal form that people had used for better than a decade.
Yeah, I think so.
And I guess where am I going from this? That, you know,
Mr. Barry, I think that is specifically, I think that's specifically the kind of thing that this board, again, I hate making the argument too often that this board can't do whatever, but in my objection to, the granting of refunds thing, one of the cases that I came across said a board specifically can't make decisions about estoppel, and that's basically what that is saying this has been in place for so long that it must be the law. I just don't, this board is pretty limited to the code, meaning Title 23, as opposed to principles of grandfathering and whatever else. I mean, I think those things are fair, common sense things to sort of consider, but I don't think that that's a ruling that's within the jurisdiction of the board.
I understand that, but where I'm coming from is we had enforced $50 and $15 for a long period of time, and that was the way it was enforced. What we're really arguing about really isn't the 15 and the 50, it's the 1.3 multiplier. That if everybody accepted the 15 and 50, all we're dealing with then is the multiplier. Did I lose everybody?
Excuse me. I believe I follow what you're saying, Mr. Chair. I think that from our perspective, whether it's 50 or 65, the 1.3 times 50, either of those had the effect of improperly setting a fee.
Chair? I guess I would like to, when I'm reading all the definitions that you put into here as to why they can't, why a policy can't set a fee, I guess there's nothing in here that specifically says that. If you have a legal mind, I guess you can read through all four of these and string something together that makes it appear that way. I mean, I guess I'm not as confident when I read all this that that's what it says. Essentially what you're saying is when they set this policy and established that fee, that they changed the code. That's what you're saying, is they changed the code by simply establishing a fee.
That's correct.
Okay. So if this policy was illegal, why did you then have to go through the 30-day process to change it, and you're having it changed through the assembly and everything? If it was illegal, you could just simply throw it away, right?
Well, we pulled it immediately. The new policy has to go through the 30-day mayoral policy of establishing a new policy. See if I can use policy one more time in a sentence.
Right. So the policy that that was in place didn't require a public comment to. It required public comment to change it. Is that what it was? Not to get rid of it, but to change it?
Excuse me. I'm not sure I understand your question, Mr.
So the policy established a fee. So the mayoral, the operating policy and procedure that you're going through is not because you got rid of that policy, but you're changing that policy?
I think what they're saying is they're not changing it because it wasn't there. They're setting a policy now.
Well,
is that, did I put words in your mouth correctly?
We are, it is correct. So I don't believe the policy number has changed, correct?
No.
So we are revising the policy through a 30.
It has been revised.
It has been revised. The 30-day period is done. It's been revised. We pulled it immediately upon determining that it was illegal.
Yeah. It just kind of seems to me that that's in recognition that this policy was needed and was valid, kind of, I mean, because you're still following the policy, you recognize the need to establish a fee for finished basements versus not having a fee, I don't know what I'm trying to say either, but since it has been around for so long, I would think that there would be a process rather than just dumping it.
Well, you caught the part about that it's before the assembly, or essentially going to be before the assembly here shortly to actually set it by code. Is that correct?
Yeah, through the chair, a point of clarification. The policy has a lot more to it than just a fee. It has basically requirements and definitions as to what constitutes finished and unfinished when you're doing a basement. So the policy does have value. I mean, one part of the policy was bad, basically. The mayor's 30-day PMP thing, that's just a policy. That's not law. So just a little point to note. And yes, the new proposed fee is going to the assembly as of today.
Mr. Edwards.
I'm curious, when this refund was given by Gretchen, what was the refund policy at the time?
Well, there's a standard, the finance department has a refund policy that we follow, where you must apply for a refund in writing, and when you do that, we generally, the permit tech, they don't bring it to a supervisor or manager, they just refund.
Is there a date, a back date on that limitation on the refunds? Say somebody else came in and said, I got a permit a year ago and you mischarged me, I want my money refunded. Was there a policy in place to cover refunds, and how far back you would go?
Through the chair, I don't think there's a specific number in municipal code in terms of like 2 years, 3 years, but I understand the state of Alaska, I'm not sure if it's law or policy, will only grant a refund up to 2 years, and that's generally the rule we follow.
Okay, thank you.
Another question here is, I'm starting to get my head around a little bit of what Mr. Thompson wants, and he would like R01 reestablished, as that was the policy as he understood it at the time of application.
I don't want it reestablished. I want it administered correctly at the time it was
You wanted it
in
administrated,
place.
excuse me. And I'm starting to understand that one a little bit. Now I'm having a little bit of trouble understanding the municipal side, that you're saying R01 really wasn't legal, thus it's not policy. Is that correct, or help me understand better? And where are we going?
Mr. Chair, that's correct. That portion of policy R01 that set evaluation for a finished basement was not legal, which is why we pulled that policy.
So is there anything being offered to Mr. Thompson on his appeal at all, or where are we going? What's the next step for the municipal side?
I think our position remains that the denial written in May of the refund request and the packet presented both at the three-member panel and here is our position on this, that because the policy was illegal, in effect, all the discussion about the board establishing that the policy was in effect on some date certain, that has the effect of effectuating a refund for Mr. Thompson's clients. And our position is that that policy was illegal. It's unfortunate. I've said that before, I say it again, it's unfortunate, but our position is the policy was illegal, had the illegal effect of setting fees. So our position remains that our decision was correct and that the fees are currently being corrected, but the fees that really should have been in place at the time would have been based on the full valuation from the building valuation data chart as applied to a finished basement.
So, in your opinion, this is about dollars then?
Well, either directly or indirectly, yes. If the board were to decide that, in your opinion, that policy was legal and was in effect on the date of the denial or the date of the application for refund, that really would be a message to the municipality that you believe that Mr. Thompson's clients are owed a refund. So in my view, it does come down ultimately to the refund question.
Mr. Ferdine.
Just so to summarize, you're saying that since the policy was illegal, it's unenforceable, and then once the Hansen program came in, that became the new legal interpretation? Or it's, I mean, so I thought I heard you say that since the policy was illegal when it was written, therefore it cannot be the basis, it cannot be enforced now for refunds.
I'm going to say correct because I believe I understand your question.
All right, so in that scenario, if the policy was illegal from day one and the municipality of Anchorage had no definition of an unfinished basement permit fee, are you saying now then, or a finished one either, that basically the municipality of Anchorage has been overcharging all permits who had unfinished basements because there was never a value applied to it until Mr. Thompson's policy?
Considerably undercharging them.
Undercharging. If the policy as written is illegal, and the only valuation data available for a finished basement is the full residential construction value in the building valuation data chart, the municipality has been undercharging for fees since whatever time the cost of a finished basement, or the cost rather of full construction, exceeded $50.
But I thought I read somewhere that there was nothing for unfinished basements.
There is evaluation for unfinished basements.
Under this table here, but back when this policy was written, was this table in effect? Yeah, that's for 2015. Mr. Thompson's policy was written back
through the chair,
a lot longer than 2015.
I can't speak to whether the building valuation data charts addressed unfinished basements in 1996 or 97. We have data that goes back some years, at least 3 or 4 years. But I would submit that the question on the table is with regard to finished basements and those fees. I'll stop there.
I just warn you that once you just eliminated that back to 96, saying that was illegal and unenforceable, you just opened a can of worms dating back to permit fees all the way back to 1996 and whether there was a chance the muni overcharged people. So just be careful.
Again, I believe that if that scenario is correct, as you describe it, we have been undercharging. Had this policy not been in effect when Mr. Thompson came in this summer and mentioned he applied for a new permit, or maybe it was last fall, and he applied for that permit for a building with a finished basement, had this policy not been in effect, our de facto, the data we would use would be the full finished construction valuation in the building valuation data chart. So the fee would have been based on $147 a square foot as opposed to $50 or $65.
And that's the way that would be enforced if I brought a permit down tomorrow morning?
Yes, Mr. Chair. If you brought a permit in tomorrow morning, it would be with a finished basement, it would be valued at full residential construction cost. Hopefully, by sometime in November, it will be lower than that.
Understand.
Mr. Chairman, is it clear that Mr. Thompson's letter or action was the point you deemed this illegal? And changed, pulled it off as illegal policy, so you pulled it off? Was his action the catalyst?
Sorry, is that question directed to me?
It was trying to go through, Mr. Chairman, but it's
Yeah.
for you, yeah.
Yes.
Thanks.
What was the duration between the time, sorry, through the chair, what was the duration from the time that this action took place, say the day that Ron came in and got his refund, before the time that you figured out or determined that that policy was illegal? What was the time span? Do you know?
Generally, Mr. Thompson submitted his refund request in November. I don't have a copy of that. It's referred to in the May 25th letter denying the refund. And that the first paragraph states, "We researched your request dated November 16, 2015." So presumably he applied for a refund in November of 2015. As I said before, I'm not sure why it sat for so long. I wasn't the building official at the time, but it sat for some period of time. It was handed to me when I took over as building official on May 1st, and I completed the research, consulted with others, and wrote this letter on May 25th, Mr. Field.
Okay, thank you.
Other questions for the municipality? Hearing none, I'll give some time to Mr. Thompson for rebuttal.
Okay, as I stated earlier, I believe the building official does have the ability to write policies, especially when it's to clarify something that's not in the code. These policies were written 20 years ago. Unfinished and finished basements were not covered in the code, not covered in the ICC table, and not built like a finished basement, like you think a finished basement is built. A finished basement just has to have drywall on the walls. You don't have to finish it out, all the trim and all that other things. That's what the policy helped declare, that it isn't like a standard, normal, finished upstairs where a person's going to go live. They had to do in the policy certain specific things to be able to consider it a finished basement if they didn't want to do it as an unfinished basement. That's what it was there. It gave flexibility to homeowners to do a bunch of things. Home builders helped create the policy. That's why it was revised so much. It was a very heated, very discussed issue with regard for many, many years, many different times. That's why in 1 year it was edited 3 times in 1999. You don't see that often unless it's a policy that's been debated and looked at and reviewed and all of those type of things. They say that policies aren't supposed to have fees in them. We talked about this at the third party. I mentioned one at that point in time. They fixed that one, but AG 11, AG 29, AG 33, they all have associated fees and numbers associated in them that may or may not match code. But it's like, it's a bad, to use that argument, you can't keep using that argument and then have policies that are under your control that have those numbers in it and try to combat me on saying it can't be done. It's done on a lot of policies. I mean, the whole thing is trying to clarify. The building official, by law, and I can ask Sam and Ross, the building official can legally write policies. Is that correct? In code, adopted by the municipal assembly. I'll answer. The answer is yes. It's been there for years. The answer is the building official can write policy. The assembly gives the building official the ability to write policies when they adopted the building code. That's the precedence that most of the time municipal attorneys don't always understand. And no, it specifically states the building official, to clarify situation that's not done, writes policy. They usually write policy. Then in 3 years when the new building code comes out, they try to, and most of you have chaired building code meetings, you try to take those policies, and if they're really not, and they really can be codified, and they should be, and you can't, you can put them into code and they're codified from that point forward. It's not too easy to codify a finished basement as designed by the citizens of Anchorage and the home builders on what they were building up here. It's not a finished space. It's not that value. I still think that we asked, and I asked during this policy, that the municipality consult the AHBA why they went through this revaluation number to go to the assembly. They chose not to, and they just put a fee together and put it forward. It is what it is. That's the part that we get to go in front of and I would think that, I would have hoped that before it went into PACE that it came to the building board, and it didn't come to the building board, and there's a code change. So they're not following the process that's supposed to be for that code change. You guys should have heard that already. I believe that's how the code is written. So they should have come to you already on that code change, and they didn't. They went straight to the assembly. That's part of this administration of code that you need to know, you need to follow, and it's important to follow, and it's required to be followed. And if you don't, you get into these little battles like this, things being done out of sync. You guys, there should be no question. You guys should have already, if it's at the assembly level, you guys should have already heard the code change for this unfinished basement and finished basement. Is that not correct? It is. It was not. It put into the assembly without your direction. That's the type of thing that I'm talking about here. Policies being changed without process. Codes being changed without process. There is processes set up. I abided by those processes. I think everybody should abide by those processes. And part of that is bringing any code changes to this body. Policies are written, that same policy section in the code passed through the building board as it's acceptable for the building official to write policy to clarify code. Those numbers that they're talking about were not in the old code. They were never there. Now they're there. Okay, one is there. Guess what it is? $15 times 1.3, it's $19.50. What did the policy say? $20. It's right there in the ballpark of exactly what it has been and always has been ID'd at. Nobody's trying to pull something over. Kent just said that my action changed. I didn't change any. That policy, if you look when I signed it, the same things were in the policy from Jerry Waite, from Ron Watts, and myself. So I didn't change it. I didn't all of a sudden decide I'm going to be smarter and better and not run through the municipal attorney and throw figures in there and numbers in there. All we did, typically when I ran the building official and when I think everybody else should subsequently, I would take your name, if you're the building official, reviews every policy and revise every policy as needed when you just take over. And that's my view. The problem is the building department hasn't had a building official that's official in that capacity for quite some time, so that's understandable. But yet, my name's on all those policies. I wrote them for a reason, to make it consistent for every one of you that get permits, for everybody in the industry that gets permits. It is important to follow those processes. It's important to know them. It's important to follow them, and it's important to keep moving forward with regard to that. And like I said, there's figures in other policies out there, and there was before, and I think at the three-member panel I said you probably should look at all those policies, make sure there's not figures. They looked at the one that I mentioned, fixed that. Here's three more. I didn't have the time to go through any more than that, but those three have numbers in there. The big thing is that ICC table, that's great. It's in there now. That means when it's in there, you should identify it, change it in code, and then you don't need the policy anymore for that piece. That's great. It's in there. Nothing wrong with that. That's what I'm talking about, following those things. If you want to change policy, change it. It's not illegal. It's just a change in interpretation. It was always interpreted that way, and all those policies, there's been many pushes from different administrations, different legal aspects, different outside groups that have said policies are illegal. It's went through the test of time. Policies are created by the building official in between the time the codes get in effect and you're supposed to adopt them, and hopefully you keep hearing that over and over and over. This was not created just at a whim. It was a 20-year-old effort, 20-year-old process. Their interpretation when I applied for a permit was that Hanson was incorrect, and they decreased the permit by that amount, not with the 1.3 factor in, without it, as the code and all their paperwork states. Then when I applied for the application, and I think somebody asked that question, it took 6 months to get a response. That's not very conducive of a building department that should answer to the question. And then so they have 6 months to basically change their interpretation. It's fine to change your interpretation, but the managerial policy, which contrary to what Ross may have just said, I mean, if you want to work for the municipality, you want to work for the mayor, you better follow the mayoral policies or you're going to hear about it, period. Whether or not they're determined legal or not, I don't know about that, but they're a municipal policy that the mayor wrote, and he wrote it very specific that says you do not change your interpretation. And in this case, they changed their interpretation sometime between November and May. So their official interpretation changed on May 25th. Obviously, that's fine. That's when I got the letter that said that they were changing how they looked at it. My view is that's their prerogative, and you can do that. I just said follow the process. Now they've followed that process, at least a portion of it. They forgot to get you guys involved with regard to the code change that they made, but at the end of the day, their obligation is to meet that policy. The policy was legal. The mayoral policy justifies that it was legal. Their interpretation and background on that show that it was handled incorrectly, and I just hope that you refer it back to them and they have to handle it correctly as a policy that was in place at the time that I filed for my refund. And I have no problem, like Jonathan said, with regard to striking out any language that says anything to do with your decision with regard to a refund. So, and I'm fine with just referring them back to the policy, and I believe that they're a fair group. They're smart about what they do. They're just misstepping a few places, and as they learn and get it right, it'll be correct, and in the future they'll have that correct. But in this tape, I believe the policy was in place. I believe it was legally created. I believe it was legal. It's just an interpretation change, and that's fine. To say it's illegal, I don't know how you can say that the building official can write policy and then say that that's illegal. The Assembly gave the authority for the building official to do that. So anyway, with that, I don't want to keep repeating myself, but as you can see, 25 years of doing this, it's very adamant that this gets done correctly and handled correctly all the time, whether I was there or whether somebody else is there doing it. That's all I care about. And in this case, it may or may not affect my clients for what I asked to be done, but the policy was in effect, and I just want them to look at the policy as it was stated. And if they say that the 2-year limit, if they overcharge people because that policy was in effect for the last 2 years, that's up those people to apply anywhere they see fit, but that policy's been changed, so there's a clock turning there. But at the end of the day, it's not right that a policy is changed, and I think that's the whole issue. They're worried about giving people the money that they're due back when a policy was in effect, and this is their way to try to say that it wasn't, and I don't think their argument has any merit. So,
questions from Mr. Thompson?
Mr. Boney, I just wanted to, I did want to be heard on a couple things, and I want to not keep it so it's a back and forth all night, so if I can refrain from argument, but I had a couple things I wanted to point out in the code. If you have questions for Mr. Thompson, I didn't want to interject, but I just wanted to, I didn't want to interrupt, but I wanted to make sure, I just had a couple points I wanted to make. I wanted to make sure I'm able to be heard.
Thank you. Let me go back to see if any questions from Mr. Thompson. Ron, did you have something else you wanted to say?
That's like a position of order. They're not really supposed to go and make statements after the rebuttal.
I have questions for legal that might allow this to, because I everything I want to hear from legal and what their opinion is.
And, Mr. Boyd, I was not going to, I guess I'm not going to argue in rebuttal. I have just a couple of things I'd like to ask about your findings that you make, or something, a couple of things to point out in the code, one in particular about the voting for tonight.
Not sure where it's going, but I'll allow it to go ahead.
Sure. The one thing, the simple thing I wanted to point out was we previously talked about the amount of voting that, or the number of people that's required to accept the de novo or to hear the de novo hearing, the majority, and pointed out, I read that subsection E. There's a different number required to vote on the, so I'm looking at, I just want to get this is not an argument, I'm just trying to get this right. Because some people have a book with new code and some people have a book with old code, I think. I'm reading from the new code. And there's 2310-103.4.4 B2, which says that an action by the building board, including affirmative action on quasi-judicial matters, which this is, requires an affirmative vote of the greater of 6 or a majority of members in attendance who are not disqualified by conflict of interest. And so I just wanted to make sure that that was something that the chair was aware of, that I think that's a slightly different voting requirement than what we were operating under E.
Affirmative vote of the greater of 6. Okay, but we still did have our 6.
This would be for the next vote on whether to grant the appeal or not.
Oh, to grant the appeal.
Is
Well, I thought
a
this was
different
to hear
standard than to, I believe it's a different standard than to hear the appeal. I'm just pointing out that I think there's two different sections there. One's B2 and the other is E.
Oh, I thought you were referring to de novo. Okay, you are referring to decisions by the board.
Yeah, that's
the
correct.
greater of 6 or the majority in attendance.
Yeah, I just wanted to make sure while I kind of had the floor a little bit to point that out. I don't know if it...
So we will need 6 in order to...
Whereas it was something like 5, I believe, or 4 or something.
It was just majority.
Right. So I just wanted to point that out.
I thank you.
The other thing is, I guess, slightly more argumentative, but I do want to draw your attention to 2310-103.4.3, limitations of authority. And I guess to avoid the bickering back and forth and me saying, again, I don't like telling the board or arguing all the time what you can't do, but I would ask that in any findings, whether it's for or against the municipality, that you make a finding related to how this appeal for a statement that a policy was in effect and should have been followed in December of last year, that rendering that decision falls within the limits of authority on 2310-103.4.3. And again, to make that as the least argumentative that I can, I would just ask that in the decisions and findings, in any for or against the municipality, for or against the appellant, that you address how this question falls squarely within those limits of authority. Just that a finding is made on that question.
You confused me just now. I need you to repeat that one more time. I'm sorry. Talk to me like it's 6.
No, that's fine. That's fine. So there's a limitations of authority section. You can probably tell my belief is that this doesn't, that a decision historically about whether a policy was in place and the building official should be mandated to follow it a year ago, I just don't believe that sort of question falls into what the Assembly had in mind when it created this board. A thing that essentially says it's a advisory opinion saying, yes, a year ago you were right and the Muni was wrong. We're going to decide that. I don't think that's really what this technical board that's, I believe, a technical board that's designed to decide things about, hey, the municipality is making me do this design thing that's nonsensical because the code says it is, but everybody in the lower 48 does it the way I do it, and I think it makes a lot of sense. So I want to bring it before this technical board. To me, that's what the intent of the board is, more than to render opinions on just whether somebody got something wrong 6 months ago. But I'm trying to avoid sort of arguing about that. So I just ask that that as part of any decision that you make a finding about how this question falls within the authority. And I think that'd be something that would help make the record more complete. Yeah.
Can you state the policy again, the number? I'm sorry. I'm trying to find it in my handbook here. 2304.
Oh. The code that I was just citing?
When you look at that, look at 10341 as well.
That's the one it should be.
No.
Things of
So this-
104. 3, 4.
And I think Mr. Thompson's right. He said, I was citing 2310-103.4.3, and he says also look at 2310-103.4.1. And he's correct. I mean, they sort of go, they're similar.
And then this, yeah,
Yes.
okay. Thank you.
I think it's a good basis to start with in any of these cases, just because it's just defines the role of what the boards are here to do.
Mr. Cullen, you had some other questions?
Just wanted to verify that my understanding of legal is that what I'm reading here is that fees for construction permits is to be established by the building board. Who establishes them? The assembly. That's
Sorry.
what, okay. I'm sorry. I meant the assembly.
Yeah, the assembly.
Okay. And so going through this logically here is what happened was you're saying that since this policy established fees for building permits, it made it, they circumvented the assembly.
That's correct.
Therefore, that's why it was an illegal policy. It wasn't enforceable technically.
That's correct. And it's a fee, so it needs to be set
So
by.
they shouldn't have written a policy for them.
Right. Correct.
So since they wrote the policy and they were enforcing it during this time, that precedence doesn't, it was illegal. So you're saying the precedence of us doing that for 10 or 20 years or whatever doesn't make it right? And that is what we're being asked to say is that we're being asked by this appeal, I believe, to basically give that credence that it was correct because of the time that it had been done before. I mean, we're basically circumventing the fact that it was an illegal policy.
Well, I don't know if you're maybe being asked to circumvent that. I mean, I think you're being asked to say it was there for 20 years, and so it should just.
We should still follow it.
Yeah, you should still follow it. And
That's not really under the purview of the building board, is the argument you're saying, is because it's.
I think that sort of argument, my opinion, I mean, that sort of argument is 180 degrees opposite from what the building board should be doing, and what a court absolutely is uniquely qualified to do is make those kind of decisions, because that's what courts do, and they're really a complicated area of law, because everybody comes, not everybody, but it's a common theme that a lot of people say, look, something's been this way for a long time, and now I want it to be that way for me too. I mean, that's something that goes on a lot in the court, and there's I don't think that's what the board is really designed to do, but in fact, I would go so far as to say they're prohibited from making that sort of call, but.
I think that's why I'm feeling uncomfortable on this, because it's not anything in my expertise to even be able to comment on.
Understand that, but as I read 2310 103.4.1, the first sentence there, in order to hear and decide appeals for orders, decisions, or determinations made by the building or fire code official relative to the application and interpretation of this code. So there was an interpretation of this code that was in place for 20-some years. Mr. Severn?
Yeah, right, there was, so I would, right, there was. I guess So what are the rules for when something's been in place for 20 years and you want to decide whether that's in place today and valid because it was in place for 20 years?
Change it. Well, I've been trying to think of, allergies and stuff like that too, and
but here's the point: is that I guess you don't know what the rules are, and I'm really treading carefully. I'm trying to be helpful, not a jerk, but it's what you know is how the code in its application should work because of your areas of expertise, and by working with the code for decades. I think what you don't know is the rules about stuff like, well, if it's been in place for 20 years, I think that's an issue for a court. That's why you'd sue somebody for damages and say the municipality is, wrongfully, they owe me $5,000 and here's why. This has been in place for 20 years. And the court's uniquely situated to say, well, here's the rules about when something's been in place for 20 years, if it's illegal, da-da-da. But the board doesn't necessarily have the skill set, really. I'm saying that with as much as I'm trying to be respectful. It's whereas a court wouldn't have the ability to understand how any of most of the technical aspects of Title 23 work at all. No understanding of any of that. But with something like, what do you do about something that's been in place for 20 years wrongfully? I just don't. I believe that's outside the.
They would ask if the policy was in place or not.
Well, where I was coming from too is, I respect Mr. Knopfsinger. He's been in this position for quite a long time and has learned an awful lot, but I'm sure on a regular basis he's learning more and more about the code and learning a new interpretation that, we didn't quite enforce that correctly over the years. So do we retroactively go back and require building owners to make changes because of a misinterpretation on this? There's also, on the other side, there's things in the building code that there are grandfather rights provided it was legal at the time it was built. And if it wasn't legal at the time it was built, you don't have grandfather rights, and you may be forced to go back. So I'm looking at this both sides here a little bit, but I am looking at this application and interpretation of the code, and there was an interpretation to some degree because that's the way it was enforced for 20 years.
Right, but yeah, sure. It gets really dicey because I would say it's not an interpretation of the application. Yeah, I don't know. I don't want to go too far down. We could go down that and be here till midnight.
Mr. Steele.
One question I just wanted to ensure I'm correct in my thinking. My understanding is if we were to deny this appeal again, the course of action, if the appellant wanted to pursue it, is in the Superior Court and not with the Assembly?
That's my...
It would, yes, if he wanted to appeal this particular... Your decision, yes, that would very much be in the Superior Court. I mean, theoretically, the Assembly is a route that's available to him on, related topics. But yes, your decision would be the venue to appeal. That would be the Superior Court.
And in essence, that's where these issues of limits of reimbursement and cost, issues of the policy being correct and in place and enforceable, carrying the legality of the law would all be determined, or it would be remanded back with us to deal with different action. Is that correct?
It could be a combination of the
okay.
two things. Right. The court could either determine some of the things and then send it back for anything that it felt was more within your area.
Thank you.
Chair?
Mr. Fields.
I guess in response to Mr. Cowling, too, in the MOA on sheet 2 and 03, they have numerous AMC chapter 399, 010, and then 1.05.060 and goes down to 2310 and over to 2310.104.15 and all the way down to 2310.104.15.1. That's their summary of how their interpretation that this policy is illegal. That's where they're saying, if you read all of these and you combine them all together, that's how they interpret that the code official cannot put a fee amount within a policy. So, but you have the right to interpret that. If you can read all that and come up with their same interpretation, then you have that right. Or if you don't come up with that interpretation, I mean, they've interpreted all of these items to come up with their conclusion that it's illegal, and that's what we have to do too, is we read it, we interpret it, and if you interpret that, yes, it's that you agree that the code official can establish a fee because that's changing code, then that's the determination you come up with. I guess everybody should probably read those and see if you determine the same thing.
But the appeal isn't to determine that. The appeal is determined if the policy was in effect, which is what it doesn't seem like that's for us to administer a decision on.
Well, the reason they're saying it wasn't in effect is because it was illegal.
Right.
But
So
you believe that it was an illegal policy, I guess is.
I would have rather them bring the appeal in as that, was it legal or not? Then I feel like I could read this and have some input on what I think the decision should be. But I feel I'm tripped up by the fact that legal's saying it was an illegal policy and shouldn't have been in effect. So I'm struggling with that if legal's telling me that it shouldn't have been enforced or in effect and they were undercharging anyway, I'm struggling with why I would be, or how that I would have the expertise to jump in there and make a determination on that fact.
Chair, in agreement with Mr. Cowling, I'm just thinking about this kind of the process that's been going here. It seems to me like one of the questions at hand is whether or not the policy was illegal, and legal is stating that it was illegal at the time. So I was just jotting some notes down here, and I just thought to myself, if the policy was illegal and therefore invalid, were the BVD charts the governing document setting the valuation totals at that time? That right there is to me, seems like a discussion of enforcement. And enforcement seems to me to be more of a legal concern and maybe not a concern of the board itself.
And to follow up, the other part I'm having trouble with is when legal's telling us it's really, they don't feel like it's in our purview to review this and to render judgment on it. I have trouble with that for me, because when lawyers tell me something, I kind of like to listen to it. I don't understand the law well enough for me to make that judgment. If he's telling us we don't have jurisdiction there, I think we got to analyze that as well.
I don't feel like I have the expertise to determine whether or not it is legal or was legal.
And Mr. Collin, may I just make it? I always want to be careful in front of this board that I hope my comments are helpful, and I think that they are. I do want to be clear that I am sitting over here and I am advocating, and I'm not necessarily making an effort to neutrally represent the board. I'm not trying to mislead you or hide anything, but I am advocating, and I just want to, I think that's a fair statement that's fair to Mr. Thompson, too, to make, is to just be clear that that's where I sit. And occasionally, historically, there have been some questions asked of me that I've said, look, I think maybe you ought to get an attorney from my office or something like that. I try to make it clear that I am advocating for a position, and so, but
understood.
Yeah.
Mr. Chair.
Mr. Field.
Bathroom break?
Yeah, I'm ready for one too. Do we have any more questions for the appellant or the municipality other than the procedural things, the legal things regarding the case before us?
I have one, which is where we went, before we went to the appellant side, or the muni side, was there was discussions about striking things out of this that took all the refunds out of this verbiage. Is that what we should be doing during this break? Is that even a possibility to start a precedence of somebody walking in and then completely redlining out their appeal and then us voting on that? Or is it more of we can do whatever we want to do as long as our findings and facts and conclusions of law state we feel this way, but we are interpreting our vote based on this, but not this? I need some guidance about, I'm scared of redlining stuff once it gets here versus just a clean slate.
I mean, we're here to serve the general public. We have a person from the private sector that stood before us and has told us that the wording that is on his current document is something that he's willing to change, and that's the document that we go for. I mean, I've been on numerous panels before, and we've denied certain things because of how this one single document read. We said, well, now you're in here arguing something different. And so until this document words how you want it to read and what you want us to hear, how is it possible for us to rule for or against when you're talking about something completely different? So I think it's totally valid that he can strike that if that serves the needs of the
I think previous meetings with the board, we've granted or declined based on altered documents that we've stricken lines from as well, have we not? So.
Can I say something,
Procedural?
Yes.
Okay.
I have a real problem when an attorney that's representing the one side is telling you that he made an interpretation on, is telling you how you can or can't vote on something. I mean, that's the person, that's who made the decision, and then they're telling you what you can and can't do. That's not really fair representation of an appellant coming to a building board case, which is exactly what I was saying, how this whole process is. I mean, I guarantee you Sam has made an interpretation that has been wrong somewhere in his life. This could be, I'm just saying, so this could be incorrect for him. This could be just as incorrect as anything else. He says it's illegal. That's his interpretation. And he's the one that's arguing and telling you what you can and can't do, but he's also the one that's on the case board that made the determination that's against what I decided. That seems completely out of line, completely not fair for my position. And so I see how there's conflict in what you're deciding, but at the end of the day I asked one thing. I didn't ask whether the policy was legal or not. Was the policy in effect at the time? Yes, it was. Make that determination, change that finding of fact, get it back to them, let us have to sit down at the table and negotiate. That's what I'm saying. That's what I said from day one. That's a procedure, and it's not fair to get this type of twice now where the attorney that represents the city also is telling you what you can and can't do. That's not fair representation with regard to an appeal and an appeal process.
Hire an attorney.
Mr. Seal.
I have to take exception to this type of testimony because I think the point, and I've made it numerous times in the past, as an entity, we are not represented by anyone. And that puts us in a very tough position to render legal opinion. And so we're seeking anything that can offer some perspective on this in our questioning. So I think it's very appropriate we ask the questions and hear this. The deliberation may or may not be influenced, but I take exception to what's being characterized potentially.
Mr. Edwards.
We're supposed to be an independent board, independent of the city employees, and I think Ron is right in his assumption that we're supposed to be like a jury making a decision on our own. We're really not supposed to be influenced by the municipal employees, and they can make their argument in favor of the building department, but I don't think they should make arguments, especially highlighting in yellow some of the things we got prior to this, that we can and can't do something. If we want to make a recommendation to the assembly on this issue, or we want to make a recommendation back to the building department that they're doing something right or wrong, that's entirely up to us as an independent board. I think we should maintain our independency and come to a conclusion without undue influence from the building officials or the city attorney.
I think we're starting to get into deliberations a little bit here, so I'll close public hearings at this time, or not public hearings, but I'll close the hearing on this. Let's take a recess here for, I don't know, if we say 10 and end up with 15, that's typical, so we'll take a break and stretch our legs, stretch our minds, and we'll reconvene at hopefully about 8:35, and we'll start our internal discussions. Stand in recess.
And a consultant who came in and had 7.5-minute breaks with the expectation that by 10 minutes came, we'd come back.
I had one guy that
do a little slide.
Good. Well, we got meat, garlic chicken, cheese.
Are you guys still going at it?
Oh, yeah.
Okay.
And what the heck is this? Oh.
That looks like a one.
It is.
Right.
That was actually pretty
Close
good.
in a half an hour, so what I'm gonna do is I'm gonna shut that door and it locks you guys. You guys can't get out that way. You guys can get out
Go
that
that
way.
way.
But
I'll give you a call as soon as we're done, too.
Yeah.
Where do we get the clothes? Right out the
Oh no,
door.
they're right here.
You're good. I'm good. She's got a lot of the other.
Well, that'll get us to a decision quickly.
Yes. This door, yes.
No bathrooms until we
The
take a
alarm
vote.
only goes off, it doesn't do out here, but it
goes
goes
up
up
here.
there. But they already know, they can see you guys, so,
Yeah, I'll call you as soon as
I
we
don't
adjourn.
want people walking around after closing and everything when there's no meetings going on. It's really hard because I'm one person giving all the floors plus outside. Plus, well, AK's already done, so I don't want to worry about that. I close at 6. But I just want to make sure you guys are safe.
Okay, not a problem. I usually call right up.
Yep.
Right
When you
when we're
guys,
done, so.
because then I come and put everything.
I'll try to put it in the right order, too.
It's okay. See you later.
See ya. Well, we also need a copier on the same damn floor.
Yeah, you disappeared.
I was third floor.
I thought you went back to the office and no more there.
I almost did.
Second floor, there's the clerk's office with all the copier and all the other stuff. Locked. I'm like, really? You couldn't have put it out in there?
Do other boards, I'm assuming, I mean, there's like planning board. everybody has
Planning,
access to here.
UDC, everybody.
That door to the third. Yeah,
Okay.
right outside that.
Wonderful case. Wonderful case, GDC.
What? Oh, item 21?
Yeah, plans.
We,
I don't think we've met, and I'm not going to shake hands. I'm fighting a cold. I'm trying not to touch too much stuff, so.
and mine's covered in oil.
I'm Kent Coleman. I'm the acting building official, so.
I noticed that as I was going through and I was reading about acting, like, well, that's not true.
No.
She gave us the
What does
notes
acting
in what?
mean in this case?
End of March?
Well,
End of April.
end of April. I started the 1st of May, so in this case, so far, May, June, July, August, it means 4.5 months.
And you're still acting?
Still
or-
acting, yeah.
Okay.
I'm.
In the, going through the process or just
No,
kind of like?
No, my permanent job is, I work in PM&E, project management engineering upstairs at the Permit Center, and I'm the engineering design manager. So I've got 5 folks working for me there in the in-house design stuff. And, excuse me, before that, I worked in private development, which is in development services for about 2.5 years, 3 years. And then, so I had a general understanding, I'm not a building official at all, but I have a general understanding of how things work, and I knew people, and I didn't induct people when they were working for acting, so. I know the administration is looking for a permanent person.
And Ross is cemented at his spot. He's the smartest man in the building. It's like, I've seen that change, that.
I'm sorry, where do you work?
I'm with PDC. And
Okay. Now, do you guys still have an office in Fairbanks?
Yeah, we do.
You know Ken Risty?
Oh, yeah. Oh, yeah.
Tell him I said hi. He was in my, I went through 4 years of UAF with him.
Okay.
Yeah, I love Ken. He was a great guy.
Oh, he's a technical guru.
Yeah.
He's definitely one of, he's like, just let me do my design work. So we have other project managers who are like the client interface people. And Ken doesn't want to be a project manager, he just wants to. And he crushes the design.
And he, you know, I was kind of non-traditional. I was 29 when I went to college. He was, I think he was my age or maybe a little bit older. But, you know, he just buckled down, just really sharp, very methodical, thought things through. I really had a lot of respect for him. He had a full family at the time.
He's a great guy. Yeah, he's a senior associate with us.
So please tell him that Kent from UAF said hi.
I will.
And I'm for your name. I cut the
My name's Craig, and I'm for Dean there in
Okay.
Saboni.
Okay.
So I started about 96, and I, you know, was on the 2000 votes. Since then, I've been knee-deep in all this politics since 2000. I don't think I got on the board. Well, Ron appointed me to the board 12 years ago, something like that. And at that point in time, it was, oh, you only have two, because I was on the AELS licensing board, and you were like 2 terms and you're out in 8 years. It's like boom. And this 1 year was also, oh, it's only 2 terms.
You were on the state board?
I was.
Okay.
I was. now about 8 years ago. But when I got on here, it was 2 terms. But, you know, John Steele was here before I got on, and Hank Bodie was on before me too.
Yeah.
Let me ask you an AELS board question.
I'll give an opinion.
Okay, so
Boards change.
we occasionally do projects, shave and paint, mill and fill, go and road the asphalt, putting the asphalt down. Somebody, we don't know who. And we normally don't stamp those, we design them in-house, just put the drawings out, have a stamp. And we got turned into the board, so we met with an investigator.
You are completing the active engineering, are you
Is
not?
it really engineering?
There's a definition in the AELS regs about what the definition of the active engineering is. It's a pretty broad definition.
We didn't argue it, we said, you know, apparently they'd had discussion internally years ago, decided we didn't need to stamp them. Steve Schrader, I think, was the one, so.
Well,
we're not disputing it, I mean, we'll stamp them, it doesn't cost us anything to stamp them.
the bigger issue there, the ALS board and DOT have butted heads for decades. DOT just split the ALS board and we're the state. Bridges need to be stamped. No, they don't. We're the state.
I don't think
you
the
can't
state-
call this person an engineer. They aren't a licensed person. We're going with engineers.
The only entity I know that can call a person an engineer without a license is the federal government.
Well, the state does it too, like a project engineers.
Yeah,
There's a solution.
So,
so
we got caught in the roll out of that, huh?
Yeah, you can kind of like semi-umbrella under the state's DOT immunity clause, but then somebody came in and said, you're not a state, so.
And like I say, it doesn't matter to us at all, because the folks that work for me, they have their stamps, we'll stamp stuff. And it's certainly not worth fighting.
There's a lot of that's a lot easier.
Yeah. Well, you guys have a tough, thankless job. I think most folks appreciate it.
Yeah, mechanical, electrical, or
You guys
a
do,
thankless
yeah.
job.
We more and more, we're getting a lot of these things brought to the board that are more, I don't think we can even do on this. We hardly ever get the Texas stuff that comes to us.
Yeah, well, I'd like to, I think the inspectors do a pretty good job of making it clear. And so it's really off on the weeds when it gets done.
Yeah, and we just had a couple of them.
You know, the elevator placarding thing, were you in that?
Yeah.
And the
You missed
Isabel,
I missed that one.
the Isabel thing, I know was, Del Isabel, maybe you guys.
Didn't get on that one.
That one apparently went till midnight.
That went to what?
Midnight.
Which one?
Del Isabel?
What was that one about? I don't remember the name.
It was, he owns a house in West Anchorage off of Diamond.
Is this the condemning one?
Yeah.
That one occurred, right? That was like the first one I heard about, like many years ago. I remember the alcohol.
You look cold.
I am. I have something that's just blown right down on me.
Yeah, talk to Barbara.
I do. Don't you every now and then you see me doing this? Oh, you have a crossface. It reminds me of when I went to the Pentagon. They were winding us through this tunnel to get to this big conference room to talk to all these generals. And next thing you know, you look up in this corner and it's destroyed. It's like construction or somebody fell through or something. And in big red letters with an arrow, it says trapdoor. Like, okay.
I just want to chew some gum and put it under the mayor's chair.
Oh, there you go. He might appreciate that. The other one, probably not so much.
He seems to have pretty good sense of humor. With the other mayor?
Yeah. And then maybe no. We won't be able to do much like that, but I will try to get a truthfully happy of the current 2310 that they're supposed to have in their books. I will at least get a truthfully happy PDF and send it to them. They put in your book. But we really honestly between the board members, staff, and myself, and clarify that there's enough.
I think we always said
Yeah, well, a lot of this is from our three-panel job originally. Yeah, I can't. What I couldn't focus on is whether it's okay to rehear it. So once you rehear it, so I was the only one that voted in favor of the appellant the first time. The other two. But that was weird.
Those are like, you just have like your desk to yourself.
Yeah, but, well,
For a little while
that
there,
wording that they put.
they come through like little boards.
That was pretty well.
Just to say, how you doing? How you doing? You know, checking on me, yeah, that kind of thing. And then all these peters out to just like one, and then they're gone.
But you know, as
I get nobody.
two of them.
I like this is upstairs.
Not a big
It's
deal.
nice.
I don't
I like
think
it.
my opinion.
I don't complain. My temperature doesn't change. Whenever there's a building official,
I can't really say, and that's what I
they're usually 10 degrees cooler than my office.
disagree that.
So when they get one in there, do they have to raise the temperature? So one of these days, I'm just be wearing absolutely nothing in there because it's so dang hot.
Now's the time for you to move the thermostat.
They're all fake. They tell us they're all fake.
It's really easy. If you take the cover off, policy, look for wires. Sure. There's no wires in there.
Well, you can move the dial. Yeah. Yeah.
He's true.
So I guess they're in the process.
But you feel like you have control.
Now, and even if there are wires, it can still just be set to 70 degrees without
Yeah, there's this big panel in the mechanical room that
you can override it. Override everything you put in there.
upstairs.
Batter up.
I've had a lot of dealings with him since he's been on a particular project, and he's actually really level. He seems like a good guy. Yeah, totally fine. I've got no issues with him, but he doesn't, I mean, he didn't really pop to that he was pushed or strongly Christian. So I think he just assumed he's the shit. What I do.
What's the big job you're working on?
I'm doing the new South Central Foundation Children's Dental Clinic. Started out as a dental clinic only, and then went to much more than that. Yeah, it ended up in a 3-story, about 54,000 square foot building. It's a basement, 2 stories above. After they awarded it to us, they added 3 levels to it and 5 parking. Yeah, it went from 23 million to 64 million. Yeah, you guys.
What's the deal over there by the native hospital? It's all clear land over there on the way to Elmore.
Oh, yeah, well, actually, that's what we're using for staging and stuff, but they're gonna build a new, children's, like a primary care for all their staff, children's hospital. Yeah, the hospital.
I like chocolate more.
They're actually just.
It says like build the suit. What's going on?
Everybody's here. We'll call the Beanie back to order, and we are within board discussion. I guess before we go into discussion, we should make a motion toward the appeal, and then we go into discussion. Is that proper protocol, I believe? So I'll entertain a motion.
Motion to hear.
No, we've had a motion to hear. Motion to accept one side or another. Mr. Steele?
So we can start moving forward. I'll make a motion to grant the appeal as submitted in case BCA 042016.
Looking for a second.
Second.
Mr. Brady?
Yep.
Okay, thank you. Moving second. Mr. Steele?
If I might speak to the motion. First off, the motion before you was stated in the positive, which is, I think, the appropriate way to move forward with this, but I would like to substitute a motion based on my feelings and the hearing that I've heard in the initial and both tonight. And that motion I would like to put forward is to deny the appeal on the basis the building official does not have the authority and code to create or establish a fee, and the effect of setting a valuation not supported by code was illegally establishing a resulting fee. End of motion.
Excuse me, Chairman, is that a motion on a motion we haven't voted on?
It's been my understanding, I made the original motion that was seconded, and in speaking to the motion, I've offered up a substitute motion, which needs...
I think we have to vote on the first one.
No, he's... It's basically amending the motion.
So the next step, as I understand it, is I need a second on the substitute motion. We deliberate that, vote on that, and then if it carries, then we're speaking to that motion. If it fails, we're back to the original motion.
I second.
And if I might, speaking to the amended motion, what I have in essence introduced is the language that was written following the action of the three-panel board. And I think that what we've got is before us is a lot of legal perspective, ways of having done business, and items that trying to sort through this tonight is just really, I don't think, in our purview relative to what our expertise is and what the code speaks to. And so this motion, that substitute motion I'm putting forward, I think speaks to what I, after reading everyone's input here, is that the establishment of fee is one that goes to the assembly. And in this instance, even though it was occurring for years prior to that, it didn't. And the fact that it wasn't supported by that, the fee aspects are not something that is basically within our purview. And the fact that the municipality has moved forward with a substitute policy, which is addressing this issue, I think will correct it. The opportunity for the public to comment and speak about the history and the like will be afforded at the assembly level in terms of a public hearing. I would agree with the appellant that it would have been nice for the board to have been hearing these items, but that's something we can take up maybe in Commissioner's comments. But getting back to the gist of the motion I made here, is this issue may go forward in different forms based on what the appellant wishes to do. There may be a meeting of minds and with the building department and some resolution that everyone is happy with. But the bottom line is, if the appellant is not happy, this will go into a legal arena and a decision will be made. And I think that's the appropriate part for that, whether this is legal or not legal, to be reconfirmed, not with us. So I'll be supporting the substitute motion based on the comments I've made.
I guess I'm not in favor of the motion, and I would like to make a motion, if I can, to allow the appellant to reword his appeal, if you can do that or not, as we had discussed in the beginning of the process, for us to move on.
Can we do that?
Make a substitute of a substitute? I think you can.
Yeah.
I second that.
Point of order, I think what we probably should do is, if that is what you would like to do, then we should probably vote against the substitute motion
And then make another.
and then make a new one.
Okay.
Rather than, we'll get lost in how.
Yeah, I think that's probably smart.
Yeah, point of order.
I would agree.
I'm good with that. That's whatever's proper.
Additional discussions regarding Mr. Steele's motion, substitute motion. So, help me justify through the interpretation that is in, that we talked about. Because I'm kind of wrestling with that it was interpreted by the building official for a number of years, and there seems to me that there was an interpretation at that time of the values for finished or finished basement.
You're asking what aspect of my motion is speaking to interpretation historically made?
Because you're just saying it wasn't approved by the assembly, therefore it was illegal. And I'm wrestling a little bit with, but there was an interpretation that was out there for a number of years.
I would agree, and you can get into subtleties here. The policy changed over the years. The evaluations changed from the starting point of Mr. Waits to the evaluation of Mr. Thompson's signature. There was some changes in that, and I'm not denying the fact that as a vehicle was not used. I'm just saying that we're at a point in time where appeal is being made to say, okay, we would like you to tell us that, or to tell through your decisions that this was a policy, that it was being implemented, and by the way, it has some monetary implications associated with it, or could have some monetary associations. And my position on this is that I think we're in a position here of being the wrong entity to make the full evaluation of the appeal, because it does get into this very direct legal aspect of, is this legal or not? And I'm just saying, I think in my personal interest, and I think in the interest of the board, the quickest way to deal with this is to say that even though this historically has happened, doesn't make it correct for us to say, because it was interpreted, we're going to say everything's fine, and we should go forward. I'm just at the point where my position is, I think this has got enough entanglement in it relative to procedure and how the way things are supposed to be done, that it's not our purview to get into all of that detail, and that, in fact, if it wants to be appealed further, it's going to go to the courts. It isn't going to go to the Assembly. It is, and it could come back to us depending on where it goes. And the fact that the municipality is moving forward with another policy that is addressing the issues of the financial side, and the fact that it's going to have a public hearing, gives everyone in the community an opportunity to input that decision by the Assembly, which would then make it codified and get all the appropriate blessings, and we move forward. So in a way, I'm kind of saying that all the actions that have occurred out of this are dealing with the appellant's concern of, let's make sure everyone understands the rule that we all play by, and now this new rule that we all play by is codified and legal. So you may view it as weak on my part to go down this route, but my point is, I think dealing with this action and the fact of what's occurring behind the scenes is going to take it to a point where everything should be resolved. Now, we can speak of the fact that a policy has resided for so many years. I know I've sat on probably 4 cycles of codes and adoptions, and the first line is, when we have a policy, it's because it's in between codes and we want to have something that's an understood rule. And I've accepted that as my practice and the way I do things. I'll look at handouts, I'll look at policies when I design and make code interpretations. But I was always told that let's work on getting policies integrated within the codes. Now, I never served on any of the residential, so I can't speak to that, but this policy is speaking to residential, and it's been around a long time, and I'm not sure what the impetus or lack of impetus is to not have this policy resolved with in adoption of codified language, which is what goes before us and then goes before the Assembly and is approved. So I guess I'm maybe taking the easy path. I'm just saying, let's not beat ourselves up with this nasty deliberation, which has a lot of legal tentacles, because it is in the process of being resolved, and that's why I think that the action of the 3-panel is still an appropriate motion.
Other discussions?
I guess that I'll just say that for me, I guess I'm not convinced that the interpretation that the code official does not have the right to establish a fee on a policy, that is illegal. I guess I don't necessarily agree with that interpretation. And I think that, like I tried to make the point to Eric earlier, you need to read through the AMC chapters that were put in front of us by the municipality of Anchorage and how they came up with making that determination. And if you come up with their same determination by reading all these, then great. But if you don't, then that's good too. It's okay. I mean, it's not like we're in a murder trial here, guys. I mean, you have a right to make an interpretation of what they've put here. You don't have to accept their interpretation. And I think that's what we're here to do. We're here to make a judgment, to make a call. If you agree with their interpretation, that's absolutely your right. But if you disagree with their interpretation of how these 4 or 5 pieces combine to say that it's illegal, then that's okay too.
I guess what I would say is, and I've read this a couple of times, is the points that have been put forward relative to, and I guess we would start with MOA page 01 through MOA 03, the description of AMC Chapter 2310, 104, 15.1. Those points are all speaking to the fact that the establishment of fees is not within the purview of the building official, and as such, an appeal of a decision based on the fact that that fee issue is not part of it is logical, and these can be introduced as findings of fact. Those are usually introduced at the time of the vote and are indicating the reasons why we reached that point, but I guess I'm comfortable in having read this twice, once in a 3-panel and once here, that the building official is not the person that establishes a fee.
And, you know, that's great. That's your opinion, and you formed that opinion, and I think that I have a different opinion of that, and that's why I won't be voting in favor of the alternate suggestion.
Mr. Ferdine.
I have a question I probably should have asked earlier. So going back through this documentation, we talk about MOA sheet 03 here, and there's been some discussions about the assembly is the only one who approves the fees. And a lot of the references they have in here are Title 23, which we've also stated is up for interpretation by this, you know, I look at Title 23 as within our purview of interpretation, as is the building official. This one paragraph here, 104.15.1, the valuation, at this point clearly states evaluations will be per the building valuation data chart with a multiplier 1.3. So the assembly approved that at some point in time. But then when we look at the table or the paragraph above that, it says fees shall be per that part below. But it said if we're a technical, blah, blah, blah. No, that's not it. The fee, there was one in here that said if it's not in that table, the fee required shall be in accordance with the schedule established by the assembly. Oh, here we go, where a technical code is adopted by a municipality for which no fee schedule is shown in this code. A schedule established by the assembly. And I guess my question is that when this wasn't put in place, we don't have the assembly's schedule. And we have in here an official form that shows what the amounts should be. Was this schedule actually some noted within the Title 23 that did get adopted? So it is actually approved by the municipality with its original $50.15. And the other thing that was noted, the policies, it sounds like they just want to surgically remove the dollar amount. So if that's correct, then the policy of defining an unfinished and a finished basement is still good since 1996. I'd see too much stuff going on in here that's just, I don't know. But I agree, whatever we do is just going to be an advisory vote anyway, so. Yeah. I guess I rambled. I really didn't have to go anywhere there. I thought I had something there, but I was hoping to try and find something that said, no, back in 1996, this is what Title 23 said. The Assembly did approve it, therefore it is approved. It's not something that Ron just haphazardly wanted to do.
No other discussions? Call for vote on Mr. Steele's motion to, deny the appeal that the building official cannot establish fees. Is that fair short synopsis?
Denied appeal on the basis the building official does not have the authority and code to create or establish a fee, and the effect of setting a valuation not supported by code is to illegally establish a resulting fee.
It looks like something you read off of
Yeah, it's
one of their
on,
summary
the
documents.
The summary action from the three panel. Yeah, I think it's part of the last page in the packet. And it is left off the first portion of the summary, reading after hearing the presentation of staff and the appellant, the panel.
Mhm.
That's the part. that's
Okay.
not in there.
There's the language that was provided to us in our packets. Call for vote.
Mr. Steele?
I vote yes for the substitute.
Mr. Fradine?
Wish my name was lower on the list. No.
Mr. Brady?
I vote against.
Mr. Cowling?
Yes.
Mr. McCann?
Yes.
Mr. Edwards?
No.
Mr. Sobolewski?
No.
Mr. Field?
No.
And Mr. Bo?
Yes.
4 yeses, 5 no.
Okay, motion does not pass. So we're open for, we're either back to our, well,
You go back to the original.
we're back to the original motion, or somebody's introduced a new substitute motion.
I guess that's where I come in again. I guess I'm not sure what that motion is going to be. I'm thinking that it should be whatever the appellant wants his document to read as. To his, is it not, won't we be voting on what his appeal document says? And what I think I've heard him say is that he wants us to find that policy R.01 was in effect, was illegal, or was in effect, is what I believe he said at the time of the appellant request at November 16th, 2015.
So the motion reads.
I need to reword that. Okay. We find that policy R.01 was in effect at the time of the appellant request dated November 16th, 2015. I guess that would be the correct, say, refund request? Was that what it was called?
You were the first.
Denial letter said.
Can I throw something toward your wording here to?
I'll take all the help I can get.
Policy R01 was legal and in effect at,
I don't think we should.
or not, or just leave that out?
If you want to.
Was in effect.
Was in effect. Okay. Looking for a second.
Oh, did he get finished? Sorry. I'll second. Can we get it read back to us again, please?
You got something you want to?
I got only part of it, so what did you get?
let's work off of yours, because I think yours is more complete. I just got a sentence, so.
Mr. Field motions that R.01 was in effect when the appellant's request came in November
16,
16,
2015.
was made. That's as far as I got.
I guess trying to simplify it, policy R.01 was in effect at the time of the appellant request dated November 16, 2015.
Moved and seconded. Discussions?
I guess that when I read the information provided as to why it was determined to be an illegal policy, I don't read that the same as the MOA. And I am pretty confident that had Ron not pushed the refund request for everyone, this policy would still be in effect today. No one would have ever looked at anything legal on it, and it would be still in effect today. But that pushing that little button of the refund request started this huge chain reaction, and that's what they're gonna come up with, is that they interpreted what was available to them to deny that request for the fear of refund. And I don't blame them. That's what I'd do too if I was the building official. But I don't necessarily read the same thing that they do from those codes. I think that this, as we already know, this isn't the only policy that was set, and not only by Ron, by others within the municipality that also had value set to them. And I don't know if they're going back and changing all of those. I think that they are. Again, I think that it was a valid policy, a good policy for a very specific reason. And I think it just got out of control. And again, like I said, it would still be in effect today had not the refund issue popped up on it.
Mr. Steele.
Speaking to the substitute motion, I'm a bit concerned and would like maybe everyone or the maker of the motion and the second to give a little more thought. But as I read the exact language, it doesn't speak to the appeal. It makes a statement about what we feel might have been in place or not in place, but it isn't attached to our action on the appeal. So I think I can't support it because it isn't addressing the appeal, which is to vote it up or vote it down. And maybe there needs to be some more wordsmithing that makes the motion speak to what action we're taking versus just making a comment about something being in effect or not. The comment can be interpreted that we're behind it, but I think it has to be a little more direct.
I would more than welcome any wordsmithing to go with it. Do we then have to vote this down before we can do another one, or can it be wordsmithed through?
Can be modified.
A process.
Usually, with acceptance of the board, you can oftentimes make friendly modifications, but they have to be acceptable to the maker and second. That's maybe not the true, pure way, but I think I see that oftentimes done and works.
Okay.
At this point right now, it basically states something that I believe even the municipality agrees with, that it was in effect that day when he came in and he did it. I don't think it'd be really helpful to his cause. So I think we do need to wordsmith more into it. Whatever's trying to happen here, which is where I fall apart, and I don't know what we're trying to get to occur.
I was trying to interpret the words that I heard from the appellant. Does anybody have any suggestions?
Yeah, that's where I'm running.
Are you working on something there?
No.
If I might, maybe a motion that spoke to a position on the appeal. In other words, that you would be supporting the appeal and a basis for the support of that appeal, which would be speaking to what your issue was of the policy being in effect. Now, you could stop at that point, but I think at least you're making a position of the board as to granting or denying the appeal, which we need to do. It may be appropriate to speak to language that removes portions of the appeal as written, which deal with the financial aspects, if that's a comfortable level for everyone. But again, and I'm more than willing to be a participant, but I do think it needs to be an up or a down on the appeal. And then we need to modify portions of the appeal that we're not supporting. And then in the end, I guess we all have to summarize this with some kind of findings of fact or a reasoning of our support.
So the motion would be to accept the appeal as written, but then modify it after we've...
Well, you can put that out there. Any motion has a risk of not getting further amendments or debate, depending on how the board acts. So oftentimes, if you wish specific amendments to be part of that, it's best to make those, but any of us can make those type of amendments to the motion, and again, it goes through the process of accepting those in a favorable vote.
I'm having a hard time with this as far as the three-person panel, the entire decision is all about the fee. So to try to take that out, it removes the entire decision. So I don't know where there's wordsmithing in there. It's all about valuation, all about fee. Mr. Thompson's up here saying it got sideways. It's not about the fee. It's about whether or not it was in place. So I'm just having a hard time trying to figure out, is there a way to modify that decision without fee or valuation? And I don't see one. So if it has to truly be based on this decision, someone's got to get real creative real quick.
Now, this might be something, if I may, that we want to get some input relative to procedure from the Muni on this, but another option would be to postpone this to a date specific with the thought that the appellant is going to submit a modified appeal and have the support of the Muni, and then we reconvene and deliberate on that revision. That might be an approach. Short of that, I agree. And I just am uncomfortable voting in favor of an appeal that has all of this components to it, yet with the bottom line saying all we're doing is supporting that it was in fact that policy. Because if for whatever reasons, whether it be Mr. Thompson's clients or other people that are aware of this, I mean, if it's challenged further and the parties aren't comfortable, it is going to go to a court setting if someone's willing to pay the money to take it there. I don't know total dollars what we're talking about. I mean, that hasn't been part of my deliberation. You know, the difference between Hanson and the fee for unfinished basement is 50 cents. So the other one would be probably the more significant for money, and whether it's to pursue that, I don't know. We've heard from, and I take it as fact, that the appellant is willing to extract the money, but it also then gets into, is it appropriate for the Muni to do that and all of their response? And unless you can do this in 5 minutes, it seems that probably a postponement would be in everyone's interest if we want to get into the detail of something that is more at the heart of the matter and what the appellant is seeking. But I would ask the Muni if that's out of bounds in terms of procedure to postpone it and look for a new substitute appeal. I've never dealt with it in that fashion.
Through the chair, if you're waiting for a response from me, we would have no objection to a postponement. We want to provide the board and the appellant every opportunity. One condition I would offer, I guess, is that if the nature of the appeal changed significantly, that we would have an opportunity to respond to that changed document.
If I might, I think the appellant, and even in suggesting that the language for the other side may need modification, I would think that that would be a given, that both sides would have the opportunity to deal with the modification and comment on the modified appeal. I don't know if Mr. Severin has any input as to we're going down shaky ground with a postponement and a revision, or?
I honestly, I really don't have much of a strong opinion. That doesn't strike me as problematic for any reason I'm aware of. I think if both sides were okay with it and the board wanted to do it, I don't think it's that objectionable.
Mr. Thompson?
He made a motion to move forward, make that statement, that's fine, and then come back for the findings of facts and the conclusion of law. That makes sense. But we were told we couldn't change the documents from the third party to now. So I don't know how we really can do that without going back through the whole process. So I'd rather see exactly what he's saying is a motion to move forward and approve the appeal, then go back and we can go together to help come up with the conclusion of law and the findings of facts, and or you know, because the decision is exactly what he said. It's that simple, and it seems like if you just quickly do that, then the discussion about the finding of facts is what we're talking about and what gets strucken out or whatever. But I mean, it's under my impression that you can't change the appeal documents. That's why we couldn't add anything more past the third-party review. But you guys can make amendments to strike those out, or ask me to strike those out, and then you guys take them and deliberate them. That's the way that I would see. And I have no problem taking the financial pieces out, like you said. So,
what it is when it is a de novo hearing, nothing can be added or changed from the three-member panel. Once it comes back, once it goes to the full board, and the board agrees to hear it, they can then accept new information at that point, like they did for the Otis elevator appeal that occurred way back in whatever. That's when that can happen. It's not before that. That's the only time.
We can modify.
You can. It's just...
We can, or we could postpone and have them modify to give us a brief synopsis, and then we could take action.
Could I take a shot at it?
You want to take a swing at it and see if...
All right. So...
throw this out for acceptance of the motion.
So prior to Mr. Fields' written, it would say, move to grant the appellant's revised intent that, and then Mr. Fields, our 0.1 was in effect at the time of the request, that verbiage. So it would read, grant the appellant's revised intent that our 0.1 was in effect at the time of the request, and then new sentences, the board does not have the authority to grant refunds, and per the minutes, the appellant has stricken all requests for refunds from their appeal.
Is that acceptable to the maker?
I'd like to have it read back in full, please.
I'm not that fast, sorry.
Well, go ahead and finish, but I mean, in terms of how you incorporated the original wording into what he was saying.
Feel that.
Does not have the authority
Does not have the authority to grant refunds. Stricken. Agreed to.
For the minutes, the opponent has stricken.
Stricken. All requests
For refunds from their
Okay. Okay. Okay, as reads, to grant the appellant's revised appeal that R.01 was in effect at the time of the appellant's request of November 16th, 2015. The board does not have the authority to grant refunds and per the minutes has stricken all requests for refunds from their appeal.
The appellant has.
The appellant has agreed. The last part is the board does not have the authority to grant refunds, and per the minutes, the appellant has agreed, has stricken all requests for refunds from their appeal.
Does that meet your intent?
Yeah, I mean, that helps make it better, you know. I mean, it certainly has the same intent in there, and that is to
Nice and loud, please.
I believe that the policy was in effect and that at the time, yeah.
Is that acceptable to the second?
Sure.
Oh, excuse me. I got the wrong second, excuse me.
Question?
Mr. Edwards.
Don't you think at the end of that, it should say he's withdrawn all requests for appeal from this board?
That'd be friendly. I'd accept that as a second.
Done.
Is that acceptable to Mr. Royal?
Everybody understand it, or do they want to hear it one more time?
One more time.
One more time.
Move to grant the appellant's revised appeal that R.01 was in effect at the time of the appellant's request of November 16, 2015. The board does not have the authority to grant refunds, and per the minutes, the appellant has stricken all requests for refunds from their appeal per this board.
Mr.
Do
Ferdine?
we need to note that this is just a advisory, or just let it ride and then they'll decide whether or not we had the authority to actually have an opinion on this or not? Just let it ride?
Yeah, thanks.
Okay.
Additional discussions? Mr. Steele?
I'll be supporting the motion. I think it covers the issues that were of concern with me dealing with the aspect of the fee. I think the language of the appellant through the minutes indicating that all considerations of refunds have been removed is maybe not as tight as I'd like to see, but I can't see language that gets us there. But I think the intent is understood, that in fact the appeal for refund is not part of this appeal anymore. And so with that, I can support the motion.
Other discussions?
I second your support. That would be a third.
Okay, call for vote.
So this is to substitute the
Yes.
the
We're
motion.
voting on the substitute motion.
Well, we're voting to substitute, and then we would vote on the final motion?
No.
We've already
done that.
We've already done that. I think these were all friendly amendments to the
got it.
motion. This one.
We have one
We have-
motion here. That's all that's before us.
All right. Mr. Steele,
Yes.
Mr. Fredine,
Yes.
Mr. Brady,
Yes.
Mr. Cowan,
Yes.
Mr. McCann,
Yes.
Mr. Edwards,
Yes.
Mr. Sobolewski,
Yes.
Mr. Field,
Yes.
and Mr. Boone, except Mr. Brady. I did, okay. Okay, and Mr. Boney.
Yes.
All right, all in favor.
Motion passes,
Motion passed.
and now we need, what,
Back to our,
law and facts?
oh, God, we're not done yet.
No, we're not done. This is where Mr. Steele generally comes in in his white coat and saves the day for us all here.
I don't know.
Unless Mr.
I
Fields has something here.
I guess I could start off with a few items that policy R.01 has been a published and utilized document since its inception in the mid-90s. And then the next part would be that, or the next item would be that the establishment of fees is the purview of the assembly, and the action of the board and the appellant is to remove the issue of the fee aspect and delve into the baseline that the policy of what an unfinished and finished basement is and constitutes. And the building board does have the authority to hear an appeal from the decision of the building official by code, and they're doing such. And I think another, whether it's a finding of fact, I'm not sure, but I would state for the record that in fact the municipality building safety department is and has pursued modification to the policy to correct the aspect of fees not having been adopted by the authority, being the assembly, and that action is underway, and that the baseline of deciding if the policy was or was not in place is the aspect of our decision, or the primary aspect of our decision.
How do you do on all that?
But I can finalize it and send it back.
Okay.
We'll have
Get
the
it on tape.
opportunity to review it.
Yes, you will.
Finding the facts and what is it, overall?
Thanks, John.
Yeah.
Sure. Points of law.
Points of law.
Points of law.
Points of law any different than that, or is it all one in this?
I'm going to be fuzzy and say that I think it's addressing both. And if I might, I should just add that and it's with my understanding that the amended policy is speaking to the building valuation forms and modifying as they feel appropriate. If I might just digress a little bit, my understanding is in the administrative policy, the establishment of value is codified.
It will be, it's going before the assembly.
Well,
No, it's in here.
I believe that it is addressed that that's where you establish fees, and it's part of Title 23.
Correct. Title 23 states, summarizing, that the building valuation data charts are the basis for valuation for construction.
And so the link I want to make is that the document going before the assembly is still addressing that link being appropriate, and it's making adjustment to the fee structure as felt appropriate.
Correct. It has the effect of adjusting the fee structure, and it will be codified in Title 23 if and when it's passed.
So again, I think, the components of the original policy and what's being modified are pointing to the same source in terms of information to be used by the public to establish fees.
Okay. Anything else? Got a little bit of business left. Update and approval of appeal forms.
Yes.
Please help.
We have what Mr. Thompson wrote his appeal on. They haven't been changed in a while, and there are certain things that we no longer do on them, and there are some things we added during the building codes went through, and I highlighted the sections that have been updated. And basically, before we can move any further and, throw them out to the public, kind of need your approval. And if you have any changes, make those changes and then go forth. This kind of helps you guys out on the front page, kind of limiting how many pages before you, that kind of thing. Time, 10 minutes here, 30 minutes, kind of setting a little bit of a precedent so we're not here for 6 hours or until midnight discussing.
And we've had some that have been very long, like trials.
Yes.
Well, really, the history behind this was the Isabella case. That's where this was really first discussed, and having some sort of limitation to the amount of information that we had to digest and then make a decision in a 3-hour process.
Right.
Because we're talking hundreds of pages that we were supposed to digest in a 3-member panel and make a decision. It was
correct.
Nuts.
And in looking through this and making these comments, we also noticed that places like the Planning and Zoning Commission, UDC, and others like this, even the Assembly, have set time limits, have set documents. So this just makes your load easier and lighter.
So is our role to just know that these changes are being made, or to approve it?
And that you accept them?
I'd like to counter that in terms of a limit, because on my years on the board, I've seen some that have been just the application form with a few handwritten notes, and then you come that evening and in walk stacks of paper. And I find that to be more frustrating than trying to limit it in the beginning. If I was making an appeal, I'd try to be as thorough as I could and put enough of that information out in an organized fashion to make it easier for the deliberation process. I think establishing a limit of 7 pages,
That's just kind of, you don't have to, you can change that, that's why it's before you guys. But we kind of wanted to say, we need this in a timely manner, in a reasonable form, so that we can get it to you guys 7 days in advance, so you do have all that time to review it.
well, then I bring up my second part, and that is that we'll get a report, a staff report, at least 3 days prior to the hearing date. So depending on the length of that and the detail, which I would like it to be as thorough as possible, that's potentially a lot of documents to absorb as well.
Staff's and the appellant's paperwork should get to you 1 week in advance. The 3 days is the fire, and I haven't had a chance to talk to fire about changing their 3 days to maybe extending it, giving it to us more advance notice in time, like 7 days.
What I'm seeing here is pretty much regurgitation of what we, as the board, decided on a year and a half or so ago, 2 years ago even, that we talked about making changes to this to limit the amount of pages that someone could submit for us to have to review during a certain period of time and give them and because lots of times we weren't getting anything till like the day before, so setting the time limit. And when I'm looking at this, like I said, it's been a long time, but this is kind of basically what I remember us agreeing to have written up, and it's finally written up.
I took that and finally have been able to push this forward.
But we all get to take a look at it and make suggestions. Right?
Yes.
Yeah, okay.
So is there my understanding is, as an appellant, I could walk in with 1,000 pages the night of the hearing and it would be accepted?
No.
So how, is that got any legal implications in terms of right of process in terms of the board?
I think what you've stated, what's being stated is that all the boards have policies on the number of pages and time limitations and everything that people can have when they appeal before their board.
And when you look at the UDC and you look at P&Z, they've got pages following that ad item identifying each piece that has to be part of that submittal, and staff reviews it for all those pieces being there before they even accept it and put it on the calendar.
Correct.
So the question here is, do we have that same detail which we're expecting?
Well, you get a 5-page executive summary plus drawings and/or calculations, and I assume other attachments.
I'm just thinking back to the Diamond High sprinkler issue, and I remember volumes of paper.
There's Delano right there.
You just asked if there were any legal things. One way to maybe get around some of it would be to say, make a procedure that somebody can ask for more. If somebody has an issue that legitimately needs like hundreds of pages of stuff because it's really that complicated, that they can say, make a request to add more or something, and then you don't get in the problem of denying someone, or if someone needs more than 15 minutes or something, that they can formally request it. I mean, because some of them, like Mr. Field was at that Isabel one, it needed a lot of paper. So it might be one way is to build in a way that somebody can, for good cause, ask to add more. Just a thought.
Regardless, materials must be turned in at least 7 days before the meeting to staff.
That gives me time to get it to you.
Now, we had talked about they had to provide the number of hard copies required, so you didn't have to do all that reproduction.
We did have that in there. And then we had them, we also stated that we could have them deliver it.
That may be a problem.
That's a problem, because the way the 3-member panel is written with the ordinances and stuff like that, basically I'm supposed to acquire everything and then disseminate. Because if they're sending you documents and then I'm sending you documents, we don't know if you've got duplicates, you didn't get everything. It's just better if it comes to one person or one group.
I like the one person be in charge of distributing. But I also like the idea that they got to provide, what is it, 14, 15 copies, plus municipality possibly, so they got to do the 16 copies, so they don't come in with, you know, a box of paper and say, okay, reproduce it, put it in binders and get it out. That's your job. Because I don't think that's, you've got more important things to do, Tana. Was there a reason that that was taken out? What was the discussion on it?
Well, I was discussing it with Sharon, the previous building official, and we figured that if I was to get these documents, I could send them over to Reprographics, and they could make all our copies, which is even cheaper than me doing it.
Mm-hmm.
And then bringing it back to me and still having one point of dissemination.
I,
But we can change it. That's why I have this before you.
Is the paper a sticking point? Could I make
just cost?
Can I make a couple recommendations? I agree that some of the stuff just cannot be. I mean, tonight's was not limited to 5 pages. The Muni alone had 13.
Well, there's attachments, and you're still allowed attachments.
But they're not
Just the executive
calculations or
summary.
drawings. So, I mean, I guess my understanding of the issue is the night of. So if they do present this stuff 7 days in advance, does anybody still want them to limit them to a page limit? 7 days out.
I think there should be a page limit.
Okay.
I just don't want to get that again.
I mean, I guess I'm of the opinion if we have 7 days out, I don't mind the amount. What I would like to add in here is any additional information that is provided the day of is limited to 3 pages per side. So if you have something that you're like, oh yeah, we meant to give you something else, you got 3 pages, because to me, reading 2 pages right before a meeting is starting to stretch my cognitive capabilities with all the noise. But I hate, by the way, and we get it from staff and we get it from the appellant, here you go, we start in 10 minutes. But I also understand there's the need that there might need to have been some new information since they gave that stuff in. Maybe there was something that was given out that they said, oh, we haven't addressed that, but we should have a separate line in there saying, you give us something the day of the meeting, it has to be limited to 2 pages or 3 pages per side. Per appellant and staff are maxed out at a couple pages.
I wish you were my teacher when I was turning in reports, because then I could turn it in, and a day later when she was grading, I could actually turn in the rest of it.
Well, I guess there's the reality of that. We're always going to get something. We're always going to get something the day of. From Tana as well. So I want to give her some flexibility to turn something in, and not someone like, it wasn't 7 days ago. Rip.
One question, I guess, it comes down to, years ago, packets used to be couriered out, and I know that might be a cost that is not reasonable and the like, but I first receive electronically the whole evening, so I print it out so I can read it. I'm not real good on working straight from my phone on that, so I print it out on paper, make comments and stuff, and then I get here, and lo and behold, I have a printed out copy that was sent to me electronically. Now, with the old days, with the packet, it was you were kind of responsible for carrying that packet and bringing it to the meeting. So if the interest is to reduce paper and all, do we need to rethink how it's distributed and get it down to the bare bones in terms of the amount of paperwork or responsibilities? That might be something worthy of thought. But
I also posted on the webpage too, so you guys can go there. I don't have to print out packets. I just do that because I haven't heard from anybody saying that we do print them out and we bring them with us.
Yeah.
So I just take that extra precaution.
This one wasn't bad. This is a few pages. This was pretty reasonable. I'd hate to print that one. That would cost a pretty penny.
Well, if we want to limit it 7 days out, what is a reasonable 20 pages? I think 5's too little to handle most of the stuff we do.
Well, like I said, that's a 5-page executive summary. As a summary, you should be able to do it in 5.
Yes.
And the 7 days is when Tanner receives it, not necessarily saying that's when we get it.
But I'm saying, but then the only other 5-page executive summary,
Plus.
but drawings and calcs, not this. None of this is a drawing or calculation.
Mm-hmm.
So this would not be admissible.
I'm thinking that that's got to be, attachments to broaden out a little bit. But, well,
5-page executive summary is right on the very front of that.
I'm going to suggest that everybody send in their comments and let Tana make a list of all the comments, send that back out, and then you vote. I mean, each board member can say, I like that, and majority rules. I don't know. I mean,
We can do that.
we aren't going to get through it tonight. I'm tired. I don't know about anybody else. Way past my bedtime.
I will let you know, the changes on the very last page, which is all the writing and everything, I just got you more space for the appellant to write on. So that's just adding more space on there and making things better for them. So you don't have to worry about that page. And then on the other page at the very beginning, I got rid of the receipt. They get a receipt, I get a copy, everybody gets a copy, except for you guys. So I got that, and I broadened out more space so that they could write more about what they're appealing, because the spaces were so small. So all you have to worry about is that front page and that yellow highlighted area.
Got it.
okay, we've got homework. Board member comments. None?
Just make one, and it was brought up in tonight's action, and as a member of the board, it would be nice to kind of receive those documents that are affecting changing policy, just for information, if nothing more, before they do go to the assembly, and I think that's probably something that is kind of a good baseline for everyone to know where everyone stands on stuff. I'm not advocating that we necessarily have to approve it, but it would be great for at least seeing that, what's happening.
Yeah, I agree. Thanks.
Anything else? Entertain a motion to adjourn?
Mr. Chair?
Oh, yes.
Before you adjourn, I do have one thing I'd like to say, not related to the case. I'd just like to offer my appreciation. Scott, Sam, and this is the results of a long day. Sam and I were talking during the break about you guys are here on your own time, and it's amazing to us that this late in the evening at 9:30, 9:40, you're still putting such attention to things that you probably really didn't sign on for. You didn't sign on to be debating policies and refunds. You signed on for the technical aspects of the code. So I just want to offer our appreciation from the municipality. I'm thoroughly impressed after having sat through 2 of these now, 3 of them, I guess, by the level of effort and detail that everybody puts into it. No matter how you vote, I don't really care about that. Just wanted to offer our thanks.
Thank you.
Back to the motion to adjourn.
Eric has motion.
Wait.
Royal seconds. We stand adjourned. Thank you very much. Thank you.